How you guys doing today? It's Anthony Gangi. Welcome to another episode of Tear Talk. Guys, we are going to revisit the David case, facts, rumors, and could it become a cold case? As we go through my feed, a lot of people are saying, why hasn't charges been placed? Could this case go cold? So I've been working on doing some research. So again, like always, we're going to take the journey together. And I'm sure by now you guys are very familiar with the David and Celeste Rivas case. I mean, it's pretty much everywhere you look now. She was found in the front of his vehicle. That was back on September 8th. And we're at a point now where we just have no idea what happened to her. Now, with that said, I did a few shows on this. Yesterday's show was extremely important. I'm very happy with the show I did because I like to provide different angles. And I think sometimes right now we're in a rush to find out what the answers are because we care for Celeste Rivas. So the rush makes sense. You know, we're passionate about what happened to her. But we're also not in a position to rush what needs to be done. So with that said, I thought we could maybe just kind of go through where we're at and why it's been taking some time to get charges or my concerns related, could the case go cold? Because that's a concern for me too. So I want to talk about the forensic timeline and autopsy procedures. So I did some search on that because I'm assuming that's the main thing right now. We're waiting for that. And we're still in the window because the window is around 4 to 6 weeks. So we're around the 4th week now. So I want to talk about deferred. What does deferred pending toxicology actually mean? So through my research, I got when the LA County Medical Examiner lists cause of death as deferred, it indicates the pathologist cannot determine the cause from physical examination alone. This is common in several scenarios. So the typical cause for deferral, and I see there's 5. One is drug toxicity, no visible trauma, but suspected overdose requires chemical analysis. And I think we're at the point now where we think that's what it could be. And I've done videos on that. Guys, check it out. These videos date back September 24th and September 26th. Some of the stuff that people are touching on, I covered almost a month ago. September 24th, it's multiple motives, including possible overdose and cult-like. And then September 26th was strictly on the overdose. Then you got positional asphyxia, death from body position, restricting breathing, often mimics natural death. Then you got cardiac events. Sudden cardiac death in young people may show no gross pathological finding. Then you got poisoning, so toxic substances that don't leave obvious physical evidence. And then you got the combination factor, so multiple contributing causes requiring lab analysis to determine which was primary. So that answers kind of why something will be deferred. So we're kind of thinking it's going to fall into one of these categories here. So then you got the standard toxicology timeline in LA County, which I looked up. Normal processing is 6 to 8 weeks for standard toxicology panels. So we are around that 4th week mark. So we're within the window now. But there's also comprehensive testing. So that could be 3 to 6 months if testing for unusual substances or multiple panels. And then there's expedited cases, high profile cases may receive priority. And then I guess for the comprehensive testing, it could still reduce it to 4 to 6 weeks. So you really we're in that window now. We're in that 4th week. We're going to be about into that 4th week. What could extend the timeline? So let's say we get past the 6th week and we still don't have anything. That doesn't mean people are hiding stuff from us. This is a unique case. This young lady was found seriously in decomposition. So decomposition requiring more complex testing methods, need for specialized tests. So you got to do date rape, drugs, designer drugs, poison, backlog at the lab. LA County processes, this is the number I got, 6,000 cases annually. Need to test multiple tissue types, so blood, liver, vitreous fluid, that's in the hair. I think that's in the eyes. So the number I got was 6,000 cases annually, just by the way, for the LA County. So if you, may know something different, let me know. But that's the research I got when I searched it. And then I have waiting for external lab results when substance requires specialized equipment. So I want to go back to the decomposition effects on evidence. So again, I'm learning with you guys. So given that Rivas's body was in a hot car, potentially 120 degrees Fahrenheit in September in Hollywood for several days, what decomposition destroys? So this is interesting. I thought this is interesting, guys. Bear with me. But surface bruising may become indistinguishable from decomposition, discoloration. Time of death, precision decreases. Body temperature, rigor mortis, liver mortis, all unreliable. Some drug concentrations can change. Some increase. Some decrease with decomposition. That's interesting. DNA from external sources, if assault occurred, may degrade. And stomach contents may be too decomposed to analyze. But what decomposition preserves? Bone trauma, so fractures, blunt force, injuries to skull, major internal injuries like organ rupture, deep hemorrhaging. Many drugs remain detectable in liver tissue, vitreous fluid, that's the eye fluid, and hair, and ligature marks on neck if strangulation occurred. Foreign objects or materials as well. So the critical issue is the confined hot environment of a car trunk or frunk accelerates decomposition dramatically. Investigators likely found the body in advanced stages, which may explain why the cause cannot be visually determined and why toxicology is essential. And remember, they gave the body over already. Family already buried the body. So most likely we really need that toxicology report. The specific toxicology panels likely being run right now. This is what they could be testing for. So standard postmortem panels include alcohol, so that's ethanol, methanol, and isopropanol. If that makes sense. Isopropanol. Common drugs of abuse are cocaine, methamphetamine, heroin, morphine, marijuana. Prescription medications are benzodiazepine, antidepressants, and then there's pain medications. And then fentanyl is a big thing now, and analogs. So now, and that's standard given this epidemic. And then the additional panels and suspicious deaths are date rape drugs like GHBs or rufinols or ketamine. And these degrade quickly and may be undetectable. Carbon monoxide and cyanide for poison, I guess. Designer drugs and synthetic cannabinoids, heavy metals and poisons, and full pharmaceutical screens. So hundreds of prescription medications. Now you can start to see the delay. And then special considerations in this case, if investigators suspect she was drugged, they'll specifically test hair samples. Drugs remain in here for months. Vitreous fluid from the eyes is the most reliable for post-mortem toxicology. That was interesting. And they may test multiple tissue types to establish drug use patterns versus acute overdose. Great to have someone on the show that has done autopsies. As the audience grows, I'm sure I'll be able to get these type of guests. Alternative causes that could show deferred status. So now we gave those categories, but there are some other things that could showcase deferred status that I think you would find interesting. So we talked about beyond drug overdoses, several causes might be visually apparent. We touched on some of these. So we have the asphyxiation scenario, positional asphyxia, being confined in an awkward position where breathing is restricted, possible in a frunk. Suffocation, if airways were blocked by fabric, plastic, or other means. Strangulation, ligature marks fade with decomposition, so only careful examinations reveal them. And compression asphyxia, so if heavy objects were placed on the body. And then medical events like sudden cardiac death, especially if she had undiagnosed heart conditions. Seizures, that can be fatal, especially without intervention. Diabetic emergency, so hypoglycemia or ketoacidosis. And then anaphylaxis, severe allergic reactions. And then the environmental, hypothermia, death from extreme heat. Hyperthermia, death from extreme heat. The car frunk itself could be lethal in September heat. That's if she was in there, if she was alive. And hypothermia, less likely but possible if she was placed there during cold night hours. Trauma that's not immediately obvious is internal hemorrhaging from blunt force that doesn't break skin, and head trauma, subdural hematoma or brain injuries without external wounds. Why this matters for the investigation? The forensic findings will determine the entire trajectory of the case. If toxicology shows lethal drug levels, investigations focus on who provided drugs, where did ingestion occur, and was it voluntary? Possible charges, involuntary manslaughter, furnishing drugs to a minor, felony murder if during another crime. I wanted to put that in so when we start seeing what could be the cause of death, what type of charges could they be looking at if these causes of death are, like if this is specifically what could have caused the death. If findings show asphyxiation, investigators focus on how did she end up in the position or situation? Was restraints used? Possible charges, murder if intentional, involuntary manslaughter if reckless. If findings show hyperthermia, investigations focus on was she alive when placed in the trunk? Did she die from heat exposure? Possible charges, murder if locked in intentionally, manslaughter, child endangerment. And if findings are inconclusive, the case becomes exceptionally difficult. Many may require circumstantial evidence to proceed. And this is why what's going on out now and running with these small stories and then them just taking on a course of their own becomes a concern because, I mean, it could destroy circumstantial evidence. And what I mean by that, it could bastardize the true meaning because we're running on all these false conspiracies. Prosecutors may be unable to file charges without a definitive cause of death, and case could remain officially open but inactive indefinitely. And that's what I'm scared about. I'm scared that there'll be a chance that we may not know what happened to her. And without knowing what the cause of death is, that part could be left still open. But you still got the relationship with the minor. And that's the question to me, is where we're at with that. So I want to talk about digital forensics and electronic evidence. So what was seized in the search warrant? So the September 17th search of the Hollywood Hills residence yielded several items of evidence, including electronic and computers. So this likely includes mobile devices, so personal phones. And they're saying David, if he was there, it could be his personal phones too, of course. Any phones found in the residence, tablets, smartwatches, got computers, so desktop computers, laptops, external hard drives, and storage devices. Then you got other digital evidence like security camera systems. Many Hollywood Hill homes have comprehensive surveillance. Smart home devices like Alexa, Google Home. These also record some audio. Gaming consoles can contain messages or videos and USB drives, SD cards. Got the Tesla. What investigators are looking for, so communication records. Text message between David and Rivas. When did they start communicating? What was discussed? Social media DMs on Instagram, TikTok, Snapchat, Discord. Remember, they're trying to figure out the relationship. They know they're connected, but let's go a little bit deeper. What type of relationship is there? Dating app messages, if applicable. Deleted messages. So forensic tools can often recover those. And group chats that might mention Rivas. And then the timeline evidence is GPS location data from phones. Where was David when Rivas died? But they got to get the timeline on that. Google Map searches or navigation history, Uber, Lyft records if need be, calendar entries and scheduling apps, recent calls, and their duration. And then you have the consciousness of guilt indicators. So web searches after death matter. Remember, in Lake and Snellen, she had some interesting searches, including giving birth and all this other stuff. These are, and I recall There are definitely some cases where they do some searches on the person's computer and it says how to hide a dead body. I think in the Emmanuel Harrow case, when Jake Harrow did what he did to promise faith, was in his computer, wasn't there searches for how to feed a baby with broken ribs? So web searches after death, how long does body decompose, penalty for concealing death, attempts to delete data, mass deletions after September 8th, encrypted messaging app usage, and searches about police investigation procedures. That's interesting. I think that's extremely interesting. Relationship evidence, so photos and videos featuring Rivas, evidence of how they met and relationship nature, any indication David knew her real age, so searches for her school, ID checks, age discussion, and financial records, payments to her, gifts or transactions. And then your drug-related evidence, messages about obtaining or using drugs, contacts with known dealers, photos or videos showing drug use, and Venmo Cash App transactions suggesting drug purchases. Then you got the Tesla vehicle data. That's the silent witness. I think that's something that's extremely important. What did that vehicle capture? So modern Teslas are essentially computers on wheels, and they record extraordinary amounts of data. What Tesla logs include, so I looked that up. They have GPS tracking, so precise location history showing everywhere the car has been. Door trunk access, frunk, all that stuff. Timestamps of every time the frunk was opened or closed. Driving data, speed, acceleration, braking, shows if car was driven erratically. Cabin camera footage, if equipped and activated, may have recorded interior. Sentry mode recordings, that's the big thing. External cameras that record when car detects motion nearby. Phone connectivity, Bluetooth logs showing which phones paired with the car and when. Climate control could show if AC was left running, relevant to time of death. And mobile app access. Tesla's app logs show who accessed the car remotely. I'll tell you something. If I was LAPD, I would want someone who knows Teslas very well to be next to me. Hopefully they're guiding them as to what that car actually offers and what people can do to go around it. I think that's important too. So critical questions that this data can answer is when was Rivas placed in the frunk? Last frunk opening before discovery. Where was the car when she was placed there? We don't know when she was placed. We just know that the car was there for a certain amount of time, but we don't know when she was placed. Was the car driven after she was placed in the frunk? Who accessed the car if David's phone was connected versus someone else? And was the frunk open multiple times? Could indicate checking on the body. That's interesting. Could the frunk have been opened a couple of times just to keep checking on the body? And then there's legal considerations. So Tesla typically cooperates with law enforcement via subpoenas. Defense attorneys may challenge the admissibility of some data, and time synchronization is critical. Teslas use UTC or GPS time, must correlate with other evidence. And then you got the social media forensics, which I think is big. So investigators are likely conducting deep analysis of both Rivas and David's social media presence. So Rivas's account, who did she follow and interact with? Did her post suggest she was meeting someone? Location tags from her post. Was she in Hollywood before? Comments from others that night provide leads. Evidence of fabricated age. Did she claim to be 19 or in college on her profiles? And that's only because they're going to try to say that he was duped, but it doesn't matter. You're still the adult. And that's when it comes to establishing what's their relationship was beyond just that connection. But if he's grooming her, that age is really not going to matter. That's just become a narrative in the media right now. And stories and temporary posts. Platforms retain these even after they expire. So for David's account, DMs with Rivas and others, posts that coincide with relevant dates, followers who might have information, any posts that were deleted around the time of Rivas's death, and metadata from photos, again, location and timestamps. And guys, people still make that effort to delete it, even though they know it can be found. They just do it. They don't want to leave it. They don't want to make it obvious. So platform cooperation. So Instagram, Facebook, Meta usually cooperates with law enforcement's requests and retains deleted messages. Snapchat claims messages are deleted, but some data may be recoverable from servers. TikTok cooperates with U.S. law enforcement, retains substantial user data, and Discord will provide data with warrant logs and their. Discord will provide data with warrants, and logs are comprehensive. The fake ID question, if Rivas misrepresented her age online, investigators need to document screenshots of profiles claiming she was older, statements from witnesses who heard her lie about age, any fake identification she may have possessed, and whether David ever saw her real ID or had reason to know her true age. I mean, if that ever gets brought into court, I would still object as a lawyer, but if you got to do an objective investigation, you should be fair. I still think you could still present that. And again, the onus is on the adult. So even if you show it, it doesn't hurt. It doesn't hurt her case. It adds weight that David was, we're adults. So keep on pushing the fact that you thought she was 19. It's still not going to minimize your level of accountability. So the digital analysis time frame, phone computer forensic examination timeline. So initial extraction is 1 to 3 days, and there's creating forensic images of devices. Then there's the basic analysis, which take 2 to 4 weeks. Text, calls, photos, browsers, and history. And there's a lot, guys. Deep forensic analysis, 2 to 6 months. And that's deleted files, encrypted data, app data, cloud services. And then there's the expert reports, additional 2 to 4 weeks to prepare court-ready reports. Factors that extend analysis is encryption. Modern iPhones are notoriously difficult to crack. Volume of data. A single phone can contain millions of files. Multiple devices. Each device must be analyzed individually. Cloud services. Subpoenaing Apple, iCloud, Google Drive, Dropbox, adds time, and app data. Each app stores data differently, requires specialized tools. So I think all this stuff is interesting because it shows you why we may be on a bit of a standstill, or it seems like it's a standstill. It looks like there's a lot of stuff going on. And guys, remember, they probably don't want to press for charges without really having all the evidence in play. So again, I think right now it's about proving, at minimal, their relationship. That's definitely got to be on the forefront. I mean, yes, the death matters too, but that relationship also matters. It's kind of got two things running parallel, and then you got the how her body ended up in the frunk. So the priority processing, high-profile cases often get expedited, but LA crime labs have significant backlogs. We talked about that. The fact that no charges have been filed 6+ weeks after the death suggests either digital analysis is still ongoing or digital evidence hasn't provided the smoking gun investigators need. So it's one of those two. I think it's still ongoing because I heard there was a lot, like terabyte upon terabyte upon terabyte. I mean, I remember someone saying something like 6 terabytes were confiscated. But again, I can't confirm or deny that. And then you got the reconstruction of events. So digital forensics can potentially reconstruct the entire timeline. That's how important that digital evidence is. It's the digital evidence that they believe can totally construct that whole timeline. So I have an example here, just an example scenario on a typical digital evidence. Example, hypothetical. September 5th. 3:47 p.m. Instagram DM from Rivas to David. 7:23 p.m. David's iPhone location shows he's at Hollywood Hills residence. 8:15 p.m. Tesla logs show frunk opened at whatever the address is in Hollywood Hills. 8:45 p.m. David's phone searches help someone overdose. 9:12 p.m. Tesla logs show car driven 2.4 miles and parked on street in Hollywood. And 9:30 p.m. multiple deleted text messages which were recoverable. See, that's an example. That's not, I'll go with that. That's not a fact, but that's an example. Look at how that worked, right? Messages, then something happened, Then let's search what happens when someone overdosed, because we're desperate here. And then, shit, I can't believe this happened. And then the deletion. This is speculative, but illustrates how digital evidence can create a minute-by-minute account. Now, everybody's talking about missing persons. That's important, and then the protocols for that. So Celeste Rivas' history of running away matters. Now, remember, I did a lot of shows on this. So I want to make it clear that I'm not blaming anything on Celeste. She's a kid. I'm not blaming anything on her family right now because we don't know. We talked about what's a troubled home to a 13, 14-year-old girl. It could be rules. We don't know. And we did use the word runaway. She could have been lured. Could have groomed her to run to him, be her savior. So, but with that said, the history does matter. So the fact that Rivas had run away or been missing several times in 2024 is legally and investigatively significant. It is. So there's a pattern that we got to look at, right? So we got to analyze the pattern. How many times did she run away? So that's the frequency. What were the durations? Hours, days, weeks, each time she ran away. Where was she found? Same location repeatedly or different places? Who was she with when found? Alone, with friends, with adults? And what reasons did she give for running away? Family conflict, relationship issues, others. And as I said, probably running two. And why this matters is because for chronic runaways are a higher risk of exploitation, trafficking, and harm. Previous incidents may reveal a pattern that led to this fatal encounter. If she was previously found with David or in Hollywood, it suggests an ongoing relationship. Her behavior may indicate underlying issues, abuse at home, mental health, substance use. We mentioned that. Now, granted, if you do have those issues and she was running to him, he's still exploiting those issues. He's still taking advantage of her vulnerability. Because as I mentioned right above, chronic runaways are at higher risk of exploitation, trafficking, and harm because they're targets. It doesn't take much to convince them to keep running. Back to you. Law enforcement response to chronic runaways. Okay, so the initial response is first runaway, treated as high priority, missing child, active search. Subsequent runaways still investigated, but resource allocation may decrease. I think you can kind of see this along the way. And after multiple returns, some agencies wrongly deprioritize as she'll come back. And I think what they don't take into account maybe is that she's being lured because there's something that she's running to, not running away from. And I think that should be established. Do we have a runaway or do we have someone that's being lured? Because ultimately, I know that they may treat kidnapping or someone being taken away unwillfully as more of a priority sometimes, but this is big too, because they could be being manipulated. So they're being forced mentally. They just don't know it. So problems with chronic runaway cases. So it diminishes the urgency. Officers may assume she'll return on her own. The lack of follow-up when found, there may be insufficient investigation into where she was and with whom. So yeah, she's back. You know, that's her again. And then there was no follow-up. And that could have happened. You know, it's going to be interesting, you know, when we start to dive deeper in this, because there'll be more questions. Trust me, when we get the answers, there's always going to be more questions. And then the missed warning signs. Repeated runaways often indicate abuse, trafficking, or grooming, and interstate coordination gaps. If she crossed county lines, trafficking becomes more difficult. Now, in California laws, police must take missing child reports immediately, cannot impose waiting period. Information must be entered into NCIC, so that's the National Crime Information Center database, and agencies should conduct risk assessments to determine level of response. The risk assessment factors are age 13 and under is higher risk, 15 is moderate. Mental health or medical conditions you look at, prior runaway history, suspected abduction versus voluntary departure, we talked about that, and environmental conditions, weather, dangerous areas, etc., and evidence of being with adults. So that's interesting. So they should be taking all that into account, and that could probably heighten the urgency. Social service involvement. So question that we need exploration during these cases, and this is what we're asking now that we don't have answers on, was Riverside County Child Protective Services, CPS, involved with the family? Were there prior reports of abuse or neglect at her home? Did she have social workers or case managers? Was she in the foster care system or living with family? And were there mandated reporter notifications from her school about concerns? We don't have any of those answers, believe it or not. Even when the media tried to push this timeline of 11 times they were called in 2020, whatever it was. I mean, there was a kid, I showed this video on it. I put it on here. That's from TikTok that broke down an explanation of those phone calls, those 911 calls. And most likely it really looks to be in like kind of running parallel with her running away and maybe the follow-ups to those runaways and looked like a family that cared. And then the timeline, but she showed up on September 8th and the family in 2024, the day after her birthday, and her family must have lied. Who created the timeline that the family said they didn't speak? We don't know if that's even legit. We don't know about that timeline. I mean, where did it say that the family never had contact with her? That timeline was never confirmed by LAPD and was never confirmed by the family. I did a video on that too. Everybody's like, oh my God, the whole narrative has been rearranged because obviously the family lied. When did the family say that? When did LAPD say that? So why this matters? If CPS was involved, there should be documented case notes about her runaways. Social workers may have information about adults she was associating with. School counselors or teachers might have known about her relationship with David, and we saw one that may have. And her teacher, who later posted videos, may have reported concerns to authorities previously. And then I put CSEC, commercial sexual exploitation of children indicators. So chronic runaways, especially girls aged 13 to 17, are prime targets for trafficking. I thought that was unique. Investigators should examine, was she recruited via social media by someone posing as boyfriend, talent, or scout? This all should be looked into. Were previous runaways to meet boyfriends or modeling opportunities? Did she have unexplained money, gifts, or expensive items? How was she surviving? That's a great question. Were there signs of controlling relationship with older men? And then you got the interstate, inter-county coordination. Lake Elsinore, Riverside County, to Hollywood, LA County is about 90 miles. That's a significant jurisdictional gap. So coordination challenges, different agencies. So you got to have Riverside County Sheriff or LAPD, who could have different systems, databases, priorities. Communication gaps, so missing person reports filed in Riverside may not trigger immediate action in LA. Resource allocation. Neither agency may own the investigation if she's moving between both. And conflicting information. Family reports her missing in Riverside, but she's found in LA. Was LAPD notified she was a runaway? Best practices often not followed. So when runaway is found in different jurisdictions, that agency should interview her about where she stayed and who she was with. I mean, who found her? Riverside County or LA? Who brought her back home? Information should be shared back with originating agency. Like, that's another thing. I mean, if LA found her and brought her back, was Riverside informed? Was Riverside County informed? Or they just say, hey, LAPD brought her back, we're good. You know, we have her. So maybe there's no further action on our end. I mean, that's interesting. Information should be shared back with originating agencies, so we don't know if that even happened. And if pattern emerges repeatedly found in same area, specialized units should investigate potential trafficking or exploitation. Schools should be notified of extended absences. That's another thing. I would love to know that too. You know, with the school, what were their actions when Celeste Rivas Hernandez wasn't going to school? Do we have any, would they have truancy visits or something documented? I know even after she was reported as a runaway, I mean, what was her, that's from what the parents, where did she go during the day? Maybe when she was supposed to at school, did she go to school or was she with him? So I'd love to see a little bit more of that because they could have just maybe had smaller interactions before she started running away to him fully. Maybe she didn't just run away with him the first time they met. Maybe it was during the school hours where she was expected to be at school. So the school didn't follow up. The parents would never know. And then eventually she built enough trust to run away for longer term. So critical question. When Rivas ran away previously and was found, did anyone interview her thoroughly about how she got to Hollywood, where she stayed, who she was with, how she met these people. If these interviews were conducted and documented, they might reveal that she had been with David before, which would be critical evidence. The teacher's video and school response. So Rivas's teacher posted a video after her death. That raises questions too. What did the teacher know? Did Rivas talk about having a relationship with an older person? Did she mention David specifically or show classmates his music? Did she tell friends she was going to meet him? Did teachers notice warning signs, grooming indicators, changes in behaviors? And was this documented? Did you let anybody know? And the mandated reporter obligations. California law requires teachers to report suspected child abuse, including sexual abuse or exploitation, child endangerment, or knowledge that a minor is in relationship with adults. It's right there. If the teacher suspected something, did they file a mandated reporter claim? Did the school counselor follow up? Were parents notified of concerns? Were police contacted? And then post-death video ethics. Is the teacher posting videos after Rivas' death is controversial? Was it appropriate to share information publicly? Did it violate student privacy, even posthumously? Could it affect the investigation or potential trial? And what was the teacher's motivation? Grief, guilt, wanting to help investigation? I mean, I showed the whole class that what we doing there. I was always curious about that, so I wanted to put that in there. So now we have to go to the timeline reconstruction and parking violations. That's the 72-hour parking citation timeline. This is one of the most concrete pieces of evidence in this case. So how 72-hour parking enforcement works. Officers mark the tire with chalk or takes photo of the license plate, return 72 hours later to check if vehicle was moved. If still there, officer issues citation. After citation, vehicle can be towed if it remains. Critical question. And we know a little bit more about the vehicle, but it's still not been confirmed. It's not coming from the lead in the investigation. It's coming from the private investigator. When was the first chalk mark photo taken? This establishes the earliest the car could have been parked. When was the first citation issued? This confirms the car had been there at least 72 hours. Was there a second citation? Multiple citations suggest the car sat there for days. And when was it towed? This establishes when the body was discovered, September 8th. That little window, we obviously know. And that was actually sent to the public already. So we do have that part. But when they mentioned the car being there at the beginning of July, and that still hasn't been confirmed. But right now we know within a small time frame, that's up until the body was discovered September 8th, that towards the end of August to the beginning of September, this is where the car was, and this is what began the process of managing the citation. And that's actually those records have been released. Someone had, I think, the investigator brought those out, and it's coming strictly from the agency. So an example timeline, just hypothetical. September 2nd, car was first marked by parking enforcement. September 5th, first citation issued. Car there for 72 hours. September 8th, second citation. But we know it's not true. So basically, the car was towed on September 5th, brought to Hollywood Tow. And then I guess there was a weekend. And then on that Monday, they got the smell. And that's when they discovered the body after the search warrant was provided. So why the timeline is crucial is it establishes a window for when the car was abandoned. Combined with Tesla data, it can show who parked it there. It may establish that Rivas was already dead when the car was parked, if she was placed in front before parking, and it could indicate whether David or someone else parked the car. The location is very significant. Where exactly was the car parked? It's around 150 feet from the rental home. Was it in a residential street or commercial area? We know this already. How far from David's residence? Was it in front of any business with surveillance cameras? Is it in a location David frequents or somewhere random or unfamiliar? And we kind of know that information already. It's already been released. We're pretty much aware where that car was and how far it was from the residence that was being rented by the manager, Josh Marshall. Location analysis can reveal. So what we got from this was near his residence, suggests he parked it there maybe or possibly planned to return to move it. Far from residence suggests intentional disposal, trying to distance himself from vehicle, but it was pretty close. High traffic area, risk of discovery was high, suggests panic rather than planning. And low traffic areas suggest more calculation. Chose spot where car wouldn't be noticed quickly. And then you got the witness canvassing. So LAPD investigators would have canvassed the area, and we know they did. Did residents notice when the car appeared? Did anyone see it being parked or anyone accessing it? Were there homeless individuals or regular pedestrians who might have noticed activity? And do any businesses have security cameras with views of where the car was parked? The whole neighborhood. It's a high class neighborhood. They every one of them has cameras, high quality cameras. So they definitely got footage from there. And we're sure of it. That's pretty much that part's been confirmed. Vehicle ownership and access, registered owner, Tesla registered to David Anthony Burke. That's his legal name. Does he own it outright or is it leased? Is anyone else listed on registration or insurance? Who had access to the vehicle? David, obviously, manager or personal assistant, family members, friends or associates. And then there's the key phone access, Tesla key cards, who had them. Phone access, Tesla apps can unlock and start car, whose phones were authorized. So I'll be interested whose phones had the app for his vehicle. And valet mode or loaner scenarios. And why access matters. If others had access, defense could argue someone else used the car without David's knowledge. That's if, the lawyer that's solely representing David. That would be interesting too. If you definitely start seeing a divide in the camp when shit starts hitting the fan and everybody starts pointing the finger, and then it gets more confusing, but it's always expected. If only David had access, it's much harder to deny involvement, and phone logs showing which device opened the car are critical evidence. By the way, when I said before valet mode or loaner mode, just to be clear, valet mode in a Tesla locks down the car when someone else is driving it, limiting speed and acceleration, hiding personal info, and locking the glove box trunk. A loaner scenario is when Tesla gives you a temporary car during service, or you let someone borrow yours, often with restrictions like valet mode to protect the vehicle and your data. All right, so now let's see. We did why access matters. So if others had access, defense could argue someone else used the car without David's knowledge. If only David had access, it's much harder to deny involvement. And phone logs showing which device opened the car are critical evidence. And then you got the tow yard discovery. Why did tow yard employees check the frunk? Well, standard procedure, check trunk frunk for valuables before storing vehicle. The foul odor, so decomposition, smell was likely overpowering, and visual inspection. They may have seen flies or other indicators. Could be a few things, but we definitely know it was the smell. What happened next? Employees immediately called 911. LAPD responded and secured the scene. Coroner was called to remove body. Vehicle impounded as evidence. Remember, they got a warrant, so the body was legally recovered. No concerns there. And the tow yard testimony will be important. What was the conditions of the body when discovered? Was it dismembered? Was it not? That seems to be another thing, and I did a video on that. Was the trunk locked or unlocked? Were there any other items in the frunk with the body? And what did the interior of the car look like? Cleaned, recently, smells, evidence of occupancy. Now, we have been wanting to know why hasn't anybody been charged? So I had to look up some things, but I also had to make some phone calls. I called a few good friends of mine. Some of them have been on the show. And these are some of the things. Some of them are not too familiar with the case. That's why it's harder sometimes to get them to come back on the show because they have to do research. And a lot of them don't want to come on unless they're more familiar with the case. But in general, so legal standards for charging decisions, probable cause versus proof beyond reasonable doubt. So for arrest, probable cause, we want reasonable grounds to believe a crime was committed and the person committed it. I mean, here you at least got concealing the body, possible grooming, but you definitely have concealing the body. Can be based on circumstantial evidence, much lower bar than trial conviction, and based on totality of circumstances. So that's the probable cause. So reasonable grounds to believe a crime was committed and the person committed it. Can be based on circumstantial evidence because it's probable. Much lower than the trial conviction and based on totality of circumstances. It's just enough to get the charge. For conviction, proof beyond reasonable doubt. So where we need to go with this in order to convict the person. We got the person here. We're charging them to try to start looking for things. Because, again, that's why it's a lesser standard at the beginning, because we're trying to figure it out. But do we have enough to at least start the momentum? Yes. Okay, hold them. Let's do what we got to do, charge them. And then eventually when it goes to trial, that's where it's proof beyond a reasonable doubt, because now you have to be on point, because now this is about the conviction. So jury must be convinced to a moral certainty. Evidence must exclude every reasonable hypothesis except guilt, much higher bar, and requires jury to believe prosecution's theory. The gap between these standards explain why no arrest yet, possibly. Police may suspect David was involved, but without knowing how she died, they can't establish probable cause for murder. Even if they strongly suspect him, they need enough evidence that a judge would hold him for trial. Now, can prosecutors charge without knowing the cause of death? Generally, no. The corpus, it's a tough one. Corpus delicti problem. Corpus delicti means body of the crime. The prosecution must prove a crime occurred, so that's the corpus delicti, and the defendant committed it. Forgive me if I said it wrong. Work with me. Without a cause of death, can't prove a crime occurred. Maybe she died of natural cause. So again, all we have is the concealment. And then can't determine appropriate charge. Murder versus manslaughter versus accident. Can't establish intent or mens rea, state of mind. So historical procedure, by the way, in Emmanuel Harrow's case, even though they didn't find a body, they had enough evidence in the house to believe that the child was killed. And then there's the past history of Jacob Harrow, but also he took guilt anyway. But I think there was also somewhere along the line, not a confession, but he must have told somebody that either he killed the baby on laying on top of it, or he killed the baby through abuse and then threw the baby out and then got lost through waste management, or just buried it somewhere out in the desert. But there was enough there without the body through the evidence that they gained. So evidence of abuse, I mean. So we have no idea truly what they found just yet in that house. But here again, so you can't establish intent or state of mind. So historical precedents. Some high-profile cases charged without a body or cause of death was Scott Peterson charged with murder, even though Lacey Peterson's cause of death couldn't be determined due to decomposition, and Casey Anthony charged with first-degree murder, even though Kaylee's cause of death was undetermined. What made these cases different is overwhelming circumstantial evidence of intentional killing, kind of the same thing that you're seeing now with Jake Harrow's case. No plausible explanation for death other than homicide, and suspicious behavior by defendant. Lies, cover-ups, etc. Now remember, for Celeste Rivas, people still think it could be an accident, it could have been a drug overdose. So there's other reasons there. So in this case, there is a body, but cause of death is unknown. Multiple plausible scenarios: overdose, heat, death, asphyxiation, homicide. I mean, you could something as she locked herself in the trunk if she could fit in there. I mean, as unreasonable as it sounds, until autopsy is complete, charging would be premature. So the concealment charge, we talked about, that's PC, what is that, S152? Prosecutors could charge concealment, prosecutors could charge concealment now, even without knowing cause of death. So every person who willfully conceals the death of any person is guilty of a misdemeanor. Only requires proof that one person died, 2 defendants knew, 3 defendants concealed it. So again, only requires proof that 1, a person died, 2, that the defendant knew, and 3, the defendant concealed it. Does not require proof of how they died. So I don't want that to come out wrong the first time. I meant to say 1, person died, 2, the defendant knew, 3, the defendant concealed it. Why they haven't charged concealment? It's only a misdemeanor, max 1 year, county jail. Charging it now might compromise a larger murder case. Use immunity problem. If David makes statements about concealment, they might not be usable for murder charges. And strategic, better to wait for full evidence before moving, because it's a smaller charge. If you get them for the murder, maybe the concealment could be negotiated. Or if he had some responsibility for the death, let's just do that. Charging timelines and statute of limitations. So California murder, there's no statute of limitations. Can be charged 10, 20, 50 years later. Don't matter. No more pressure no time pressure to file charges. So we got time. Other potential charges: manslaughter, 6 years from date of crime. Child endangerment, 6 years. Statutory rape, 10 years for felony level or 1 year for misdemeanor level. Concealment of death is 1 year. The strategic calculus, if this is murder, prosecutors can wait years for more evidence. If it's lesser charges, clock is ticking, must file within statute of limitations, and this creates pressure to determine cause of death quickly. Obviously, then it makes sense to try to see if you can speed the charges across, because you don't want to lose the smaller misdemeanor charges. But having said that, the smaller misdemeanor charges are the ones that have the time limit. So arrest timeline after evidence is gathered. District attorney reviews evidence from police. DA decides whether to file charges. If filing, defendant either A, will be arrested and arraigned within 48 hours. We've seen that multiple times with all the cases we follow, or B, allowed to surrender. In high-profile cases, self-surrender is mostly common. Post-arrest timeline, so you have the arraignment, that's within 48 hours of arrest. Then we talked about the preliminary hearing within 10 court days or waived. And we actually have seen them waived, which was unique. I think Manuel Harrow's case, they waived it. And then the trial must begin within 60 days if defendant is in custody, or defendant can waive speedy trial rights. Now, I want to talk about the statutory rape and age verification offense, because we know that's here. We know that's something that we believe has a lot of evidence that can at least connect him to her, and then we just have to figure out why. So the law, this is California statutory rape law, and I saw that as S261.5. Unlawful sexual intercourse is an act of sexual intercourse accomplished with a person who is not the spouse of the perpetrator if the person is a minor. Key elements: sexual intercourse occurred, the other person was under 18, and that's it. Consent is irrelevant. Mistake of age is not a defense. And it doesn't matter if our IDs were 19. And I know they keep on pushing it. They keep on pushing it. They keep on pushing it. And I'm sure defense lawyers, if this was a case, will keep on pushing it. But clearly, it's not a defense. Penalties depend on age difference. Misdemeanors, if perpetrators are older than 3 years, up to 1 year in county jail. Misdemeanor or felony if perpetrator is... Sorry, well, hold on. Let me read this again. Misdemeanor if perpetrator is less than 3 years older. Sorry, that's what I meant to say. Misdemeanor if perpetrator is less than 3 years older. Misdemeanor or felony if perpetrator is 3 years more or older. Up to 1 year of jail or state prison. Felony if adult is 21 plus and victim is under 16 in California. 2, 3, or 4 years in state prison, depending on the age of the victim. In this case, Rivas was 15. That was confirmed. David is reportedly 20 to 21 years old. Age difference is 5 to 6 years. If sexual contact occurred, it would be a felony. The mistake of age defense in California, the hard truth, California does not recognize mistake of age as a defense to statutory rape. So all that stuff you put in about fake IDs and irrelevant. This is a strict liability crime. People versus Olson, 1984, court held that reasonable belief that a minor was 18 plus is not a defense. And then there's People versus Hernandez, 1964. Even if minor lies about age, shows fake IDs, looks adult, still guilty. The rationale, protecting minors is paramount. Adults must bear the risk of verifying age, or otherwise it's too easy for predators to claim she said she was 18. That's common sense. And guys, please, if you know people on the legal side want to add to the dialogue here, please do put it in the comments, because I'm trying to put together stuff to stir up conversation so we kind of all grow in the process, because I'm learning every time I do a show. Every time I do a show, I learn. However, mistakes of age can be relevant to prosecutorial discretion. DA may decline to file if defendant was genuinely deceived. Sentencing, judge may consider in mitigation, and public perception, not a legal defense, but affects how case is viewed. Evidence of age misrepresentation. What would constitute proof Rivas lied about her age? So social media profiles listing age as 19 or birth year as 2006 instead of 2010. So I'm curious about that. So she could have had IDs that said she was 19. But what did her social media platform say? And everybody knew she had a social media platform. Did the social media platform say she was 19? Because no one's talking about that part. And the social media platform, to me, would have been something more people would have knew of. I mean, think about it. If she had a social media platform that said she was 19, her friends or somebody would have said that, because she may have hid IDs to only the people that would require her to show them. But the social media platform would have showed, hey, why are you saying you're 19? Why are you saying you're born in 2006 or whatever? Statement to witnesses. She told me she was in college at USC. Fake identification, driver's license, college ID. Physical appearance, looking older than 15, which I still think she looks young. And context clues, meeting in 21 plus venues, using dating apps with 18 plus requirements. But that social media is key. What investigators are looking for: screenshots of her Instagram, TikTok bio showing false age, messages where she explicitly tells David she's 19, witnesses who heard her lie about her age, any fake ID found in her possession, and dating app profiles, Tinder, Bumble, are 18 plus. Her presence implies false age claims. The he should have known factors. Even if she lied, prosecutors might argue he should have realized her appearance, that she looked 15 or 14 or 13. That's what it really is, 14 or 13. Her behavior and maturity level, no driver's license or adult context markers. Knowledge that she was in 7th, 8th grade, if he knew, and her being a runaway suggests troubled minor, should have prompted questions. She's a runaway? And how old is she? 19? And she's a runaway? Reasonable belief, when it doesn't matter legally but matters practically. As a legal defense, it fails in California as a factual defense in court of public opinion. If David can show she created elaborate false identity, used fake IDs, told consistent lies about being a college student, looked and acted like an adult, then public may be more sympathetic, even if law doesn't excuse him. So again, I know the media is pushing it, which it's a narrative just to put the blame on her. It's upsetting. As mitigation in sentences, if convicted, defense attorneys would argue for leniency. He was deceived by a sophisticated minor who deliberately targeted him and could result in lower end of sentencing ranges. Don't forget, she could also set her age, or someone else could have set her age. I mean, even if she didn't say, if someone said, hey, Dave, that girl you with is 13, do your due diligence. As factors in DA charging decisions, if evidence clearly showed Rivas was the aggressor, pursuer, and lied extensively, so you're telling me she's chasing him and he's a victim, DA might decline to file statutory rape charges, or might charge lesser offense, or might charge but offer plea deals with minimal jail time. I don't see that as being the case, but I had to put it out there. The social media evidence question: if Rivas' social media showed her posting from USC campus, implying she's a student there, using hashtag adulting or similar hashtags, showing fake ID and photos, hanging out with people clearly in their 20s in adult venues, this helps DVD argument that he was genuinely deceived. So there's a lot there that would have to be utilized. So it's like, hey, she gave you a fake ID. Anything else that you can lean on? And if you had all these other things, that's interesting. But how do we know he didn't even get her those IDs? He could have got her those IDs. Again, that hasn't been mentioned. Additional charges beyond statutory rape, so contributing to the delinquency of a minor. That's PCS 272. So misdemeanor: anyone who encourages, causes, or contributes to minor becoming a delinquent, runaways. Could apply if David provided drugs, alcohol, transportation for runaway, etc., fake IDs. Even if no sexual contact, this could be charged. Furnishing drugs, alcohol to a minor, if toxicology shows drugs in her system. If evidence shows he gave them to her, those could be separate felony charges. Child endangerment, there's another one, PC 273A, felony, willfully causing or permitting a child to suffer unjustifiable physical pain or mental suffering. Could apply if he knew she was a runaway, provided drugs, or put her in dangerous situations, and doesn't require sexual contact. Annoying or molesting a child, misdemeanor, motivating the act by an unnatural or abnormal sexual interest in children. Could be charged if there was inappropriate contact, even short of intercourse. So the complex question is, did he know? This is the critical question for any statutory rape charge. Evidence he did know she was a minor would be she told him her real age. He saw her school ID or learned what school she attended. Again, he's also, there's rumor that he was paying off her friends. Well, who were her friends? What was that social circle? Her behavior appearance made it obvious. He searched for information about her and found her real age. And others told him that girl is 15, or at the time 14 or 13. Evidence he didn't know she was a minor. Okay, her social media said she was 19. She showed him fake ID. She claimed to be a USC student. He never saw evidence of her real age. She acted like an adult. Their meeting context suggested she was an adult. For example, met at 21 plus events. Digital forensics will likely reveal the truth. If his phone shows searches for her school, he knew. If messages reference her age, conclusive either way. If he told others she's 14, 13, 15, he knew. If no such evidence exists, supports his claim of not knowing. But won't carry much weight because California doesn't lean on that. That's where they have to draw sympathy through public opinion. And that's where the media is playing that card, because they know the law will be a problem, so they try to draw the sympathy, in my opinion. Strategic defense considerations. If statutory rape charges are filed, defense strategy option 1, I didn't know. Factual defense, not a legal defense. Admit sexual contact occurred. Argue she lied convincingly about age. Presents evidence of her deception. Ask for leniency in sentencing. But that's factual argument. That's the sympathy-driven stuff. It's not a legal argument. Defense strategy option number 2, no sexual contact. Deny any sexual relationship. Argue they were friends. He was mentoring her musically. Maybe. Mentoring her musically. Explain innocent reason she was in his car. Challenge any physical evidence of sexual contact. Defense strategy option 3, Fifth Amendment. Refuse to answer questions about relationship. Don't admit or deny sexual contact. Make prosecution prove it beyond reasonable doubt. And I'll guarantee you, if they were to bring him in and start questioning on that, Blair Burke would be all out over him, telling him to be quiet. And now the problem is there's an obstacle now, because if you focus too much on the relationship, it could mess up with the connection that you may need to put him where he needs to be. So that's why maybe, and I'm learning as we go, that the relationship isn't paramount right now. Again, I learn as we go too, guys. I take it all in. I'm learning, but I could see that. If I push a relationship, he clams up. He'll clam up. But if we just go and showcase the connection and really don't dive deep in the relationship right now, then maybe I can place him where he needs to be so we can find out what happened to this girl, because we want answers. And right now we don't have any. So which strategy depends on what digital evidence shows, text showing sexual relationship, what physical evidence shows, DNA, forensic evidence, and then what witnesses say. Did she tell friends about sexual relationship? And we haven't heard that. But it's just so weird for someone that age to be hanging out with a girl that young. Body concealment, law and case. I want to go to the body concealment. So the statute, every person who willfully conceals, hides, or removes from the place of death or where the party may be found, any person, okay, hold on. Every person who willfully conceals, hides, or removes from the place of death or where the party may be found, any person who has been killed or who has died is guilty of a misdemeanor. It's plain out. Elements prosecutors must prove a person died, doesn't matter how. The defendant knew, as we mentioned, the person was dead. The defendant willfully concealed, hid, or removed the body from where death occurred or where it could be found. And the intent. The concealment was deliberate, not accidental. That's why it's very important to find out when she was put in that car. Maximum penalty, misdemeanor up to 1 year in county jail, fine up to $1,000, probation is possible. What concealment means: moving body from death location to hide it, placing body where it won't be easily discovered, the frunk. And that's actually a more secured part of the Tesla too, so there's another layer there. Taking active steps to prevent discovery, covering, burying, etc. And again, that's just putting the body in the front. That would count. Wherever you park the car, it's not that you put the body on top of the car, you put the body in the front, the secured part of the Tesla. And does not require elaborate disposal. Even moving body to another room can qualify. What it does not cover is moving body for legitimate purposes, getting help, repositioning for CPR, panic-driven irrational behavior, not willful concealment, and innocent explanations for body locations. So when does concealment become felony level crime? So while PCSS 152 is a misdemeanor, concealment can be charged as felony under different statutes. Accessory after the fact, felony, helping someone who committed a felony avoid arrest punishment, requires 1, someone committed a felony, 2, defendant knew about the felony, 3, defendant harbored, concealed, aided the felon. If David killed Rivas, felony, and someone else helped him hide the body, that person is an accessory. Punishment up to 3 years in prison or up to 5 years if the felony was murder. So again, that's for being the accessory. Tampering with evidence, felony or misdemeanor. Planting, destroying, concealing, or altering evidence in context of homicide. Concealing body is tampering with evidence. If charged as felony, 16 months to 3 years in state prison. Obstruction of justice, that's a misdemeanor. Resisting, delaying, or obstructing an officer or investigation. Could apply if defendant lied to police, destroyed evidence beyond just hiding a body. And the charging decision, if prosecutors believe death was accidental, they charge a misdemeanor concealment. If prosecutors believe death was homicide, charge felony accessory or tampering. Often they charge both murder, body concealment, tampering. So again, it's hard to just get them for the concealment until you understand the death, because they have to connect the concealment to the death, how she died. So there's another reason why charges aren't out right away. So hopefully I'm answering these questions, because the one question is not so easily answered. California case precedents, concealment after accidental death. So I got People versus Archuleta. Defendant's girlfriend died of drug overdose in his apartment. He panicked. Similar, right? Wrapped body in plastic, hid it in a closet for days. Charged with the PCS 152, concealment only, not murder. Convicted of misdemeanor concealment. Court held, even if death was accidental, concealing body is criminal. So lessons for Archuleta is panic is not a legal excuse for concealment. I was scared doesn't negate willful element. Concealment charge doesn't require proof of how person died. That's interesting. So hold on. Concealment charge doesn't require proof of how person died. That's for Archuleta's case. Hold on, guys. But it's still good to know, because it tacks on to the charge. So I guess for the concealment charge, it doesn't require proof. But, I mean, I would still want to find out how she died, because that can add to the severity of why the body was concealed. So it doesn't require it. I mean, obviously I see that the body's been concealed, but knowing why does strengthen for a more harsher level of accountability. So case example number 2, People versus Morales. Defendant's infant died, cause undetermined. He hid body in a crawl space rather than calling authorities. Charged with child abuse causing death, not proven, and concealment. Acquitted of abuse, convicted of concealment. Court held, concealment conviction valid even when underlying cause of death was unproven. Lessons from Morales was concealment can be charged, proven independently of cause of death, and jury doesn't need to know why person died, only that defendant hid the body knowing the person was dead. And then case example number 3 was People versus Hogan. That was in 82. So the other case was in 2001, and the case before that was in 1988. So woman died during consensual rough sex, accidental asphyxiation. Defendant panicked, drove body to remote area and dumped it. Charged with involuntary manslaughter and body disposal. Convicted of both. Court held, even if death was accidental, concealment shows consciousness of guilt and is separately criminal. So lessons from Hogan was concealment after accidental death can support inferences of guilt. Jurors may assume if it was truly an accident, why hide the body? And prosecutors often charge concealment even in non-homicide cases because it shows culpability. And then the panic defense, which I think this is going to be something like that, but I could be wrong. Can defendant argue I panicked and didn't think rationally? So legally, no, not a valid defense. So there's PCSS 152 requires a willful act, but willful only means intentional, not premeditated. So even if you didn't plan to do it, it happened, and what you did afterwards So willful doesn't always have to have that premeditated aspect connected to it. It looks like that, hey, you hid the body, you knew what you were doing. If you intentionally hid the body, you're guilty, even if driven by panic and your emotional state. Panic, fear, shock is irrelevant to the elements of the crime. You still hid the body. Practically may help at sentencing. Judge may show leniency if convinced defendant panicked rather than coldly calculated it. He was scared kid who made a terrible mistake versus a sociopath who callously disposed of her. Could result in probation instead of jail time. And defense strategies evoking panic. My client was in shock, not thinking clearly, made a terrible decision in the moment. He wasn't trying to evade justice. He was traumatized and didn't know what to do. And as soon as he's calmed down, he was cooperating with police. It's crazy when you start reading all this stuff, how we now interpret, when those things are used. Because sometimes I'll start to draw sympathy from that. But then you realize this is just common defenses. So the prosecution usually responds with, he had hours or days to call 911. Panic doesn't last that long. The elaborate concealment, driving car to a different location, parking it there for days shows calculation, not panic. And true panic would be calling for help, not hiding evidence. Those are good arguments. So, okay, you may have panicked in the moment, but days later, no one called. They just left her for dead. So the panic thing may not help out as much as we may think. So, again, related to concealment, he may still get time if that's all they can get. It'll be crazy if that's all it comes down to, though, when they're just arguing a concealment charge. Multiple parties who can be charged. So scenario. So multiple people involved in concealment. Example, very hypothetical. Rivas died in David's residence. David and friends move body to Tesla's frunk. They drive together to Hollywood and park the car. Both leave the scene. Charging options, David, if he caused the death, even accidentally, could cross in homicide plus concealment tampering. Friend, accessory after the fact, plus the concealment. Both conspiracy to obstruct justice. The accomplice liability, if multiple people participate in concealment, all can be charged. Aiding and abetting theory, anyone who assists in concealment is guilty. And even if friends didn't help move body but provided advice or lookout, still guilty. The first to cooperate dynamic. If multiple people involved, first one to talk to the police often get immunity or reduced charges. This creates incentive to flip on co-defendants. Again, we're all about pointing the finger. And if David manager's friends were involved, police may be pressuring them to provide evidence against David. And then you got the consciousness of guilt, how concealment affects homicide cases. Even if concealment is only a misdemeanor, it's devastating on a murder defense. Flight and concealment, jury instruction. So California allows juries to consider concealment as evidence of consciousness of guilt. If defendant hid the body, jury can infer he knew he did something criminal. While not proof of murder itself, it strongly suggests culpability. The defense problem is, how do you explain concealing a body if death was truly innocent or accidental? I panicked amidst consciousness of guilt. I didn't know she was dead is implausible if she was in the trunk or frunk for days. So it creates a logical bind for the defense. Prosecution argument is, ladies and gentlemen of the jury, innocent people don't hide bodies. If Celeste Rivas died of natural causes or a true accident, the defendant would have called 911. Instead, he placed her in his trunk or frunk and abandoned his car on a Hollywood street. It's not the act of an innocent person. And remember, there'd be many reasons motive to it. She was young. She was a minor. And he wouldn't be the only person to have motive. Anybody else that was affected by David's lifestyle. So the defense counter argument could be, but it's difficult. He was in shock and made a terrible mistake in judgment. But again, she's been there for a month or however long. How long shock last? He knew he would be blamed even though he was innocent. And someone else moved the body without his knowledge. None of these are particularly strong, which is why concealment is so damaging. Yeah, he knew he would be blamed. So I'm just going to hide the body. It's selfish act. And someone else moved the body without his knowledge. Nope, not going to happen. Strategic charging decisions by prosecutors. So option one, charge concealment now. Other charges later. We talked about that, right? So the pros for that is get defendant in custody, starts court process, placates public pressure, which we're feeling now. That's why we got to be careful when we put those rush to charges. Con, only a misdemeanor. Defendant likely to make bail, may complicate later murder charges. So that's why they're not pressuring. It makes sense. They're not acting on the pressure. Option 2, wait for autopsy, which I think is what we're doing. File all charges together, because even if you find the person who drove the car, that may just be a witness, and it's only to the concealment. Pros, one comprehensive case avoids double jeopardy, issue stronger case. So you're waiting for the autopsy. Cons, public criticism for delay. Let's see, potential flight risk, evidence may degrade. That's where we're at now. And this appears to be what LADA is doing. The Los Angeles District. That's where we're at now, actually, at number 3. And option number 2. And option 3 is charge serious crime, murder, manslaughter without charging concealment. Pros, focuses on most serious conduct, concealment. Focus on most serious conduct. Concealment is just aggravating factors, not separate charges. Cons, may seem lenient. Concealment charge is easy to prove and ensures at least one conviction. So for option 3, charge serious crimes, murder or manslaughter without charging concealment. So like I said, so pro, focus on most serious conduct. Concealment is just aggravating factor, not separate charge. Okay. Typical practice in California, if homicide is charged, usually also charge concealment, tampering as additional counts. If only concealment is charged, signals prosecutor don't think they can prove homicide. And in high-profile cases, DA usually waits to file everything at once for maximum impact. This all makes sense now if you look at whatever's being thrown out in the media. So music industry and celebrity investigation dynamics. I'd hit that up too, right? Again, why haven't they been charged? I'm trying to hit up every angle. David's legal representation. So high-profile criminal attorney, that's Blair Burke. When a celebrity becomes, I have a picture of her, I think still. Right, let me just double check. Do I still have her picture? There she is. How you doing, Blair? Got that connection to the media. Great in that narrative. When a celebrity becomes a person of interest, they immediately retain a top-tier criminal defense attorney. Typical costs I saw was between $500 to $2,000 per hour. That's a typical cost. I don't know what she charged, but man, that's expensive. What his lawyers are doing right now, immediate crisis management, navigating terms of his cooperation with LAPD, controlling what David says, answer nothing publicly. That's why he's not saying anything. Of course, why hasn't David said nothing? Because he's being told not to. Monitoring the investigation, requesting updates from LAPD, and preparing for potential charges. Investigation participation, proffer sessions, meetings where David's lawyer and prosecutors discuss the case without David being charged. Controlled interview. David may have given statements to police with his lawyer present. And evidence sharing. Defense may offer exculpatory evidence, alibi, witness statements to convince DA not to charge. Public relation coordination. This is where I think is the TMZ stuff. Working with PR teams to manage public narrative, deciding when to make public statement, and coordinating with management team on career decisions, tour cancellations, etc. And then there's the fifth strategy. The Fifth Amendment strategy. David has 2 options. He could cooperate, give statements, answer questions, provide alibi, hopes this convinces public he's innocent, or he could just assert the fifth, refuse to answer any questions, avoid saying anything incriminating. Why cooperate? If he's truly innocent, statements may clear him. Cooperation looks good to public and prosecutors and can provide exculpatory evidence immediately. Why stay silent? Anything he says can be used against him. Even innocent statements can be twisted by prosecutors. Better to see what evidence police have before committing to a story. And classic advice, don't talk to police without a lawyer. You know, it's funny, and I said this in past shows, when you're first getting people's help, and you just say, hey, what happened? You know, they'll help you. They're free to pretty much draw from whatever they can. But when you start building evidence and start getting witnesses and you come back and add a little something else to the question, like tell me your side of the story, it's a bit different. I don't know what you have against me. So I start to get nervous. So that's when they start to see him shut up. So you're the first to create the narrative. You try to control it until the narrative gets somewhere different. And then you just avoid speaking altogether. Current stance. So LAPD says David is cooperating. That was earlier. They haven't said he was uncooperative. So that's another thing. They never said he was uncooperative. They just said he was cooperating, but now we got a lawyer. But that doesn't mean he's not cooperating. So this likely means he gave a statement with lawyer present. He provided phone, computer passwords, or didn't fight search warrants. He's available for follow-up questions, but he's probably not answering detailed questions without legal consultation. Manager's public denial. So David's manager issued a public denial. It was vehement, or vehemently, or vehement, aggressively an aggressive public denial when TikTok theories accused him of involvement. I did a video on this whole thing. I broke this down. Why managers get dragged into these cases, speculation patterns. The manager helped cover it up. The manager knew and didn't report it. The manager was there when she died. The manager is taking the fall for the artist. Why this happens, managers handle logistics, transportation, housing, scheduling. So it makes sense to think that. They're in the artist's inner circle. They have motive to protect the artist. Their income depends on it. We discussed that. And in previous celebrity scandals, managers or handlers have been complicit. The manager's statement, reportedly the manager vehemently, that's the word, right? Vehemently or aggressively denied any role and criticized people for saying something with no facts. And we saw that. Guys, you guys should check out my video on that because I broke that down pretty well. That was a good video. Legal implications of his statement. If he was involved, his denial could be evidence of obstruction. If he wasn't involved, his denial protects reputation but may not stop speculation. And public statements can be used against you in court. So that'll be interesting where they can go with that. I don't really think there's much there. But he did say, kind of kept on pushing distance, like he's distant, but never really said he is 100% never with David, but that he's distant. And I think there's something there when he kept on pushing himself away from David, like he knows something. What investigators are examining with the manager is where was he on relevant dates? Did he have access to David's car? Did he know about Rivas? Has he been interviewed by police? What do his phone records show? If the manager was involved, he could be charged as accessory, conspiracy, or principal, depending on role. His communication with David may not be privileged. Only attorney-client communications are privileged. And he would be offered a deal to testify against David. And there could be another scenario, too, where she was going to break up and they couldn't control her anymore. And they had to shut her up. There's just so many theories here. But I would really lean towards the overdose. And then again, having the minor in house, how it could affect so many lifestyles. I mean, this could be just anything. That's why it's not an easy case. Anybody could have a motive here. Because of the secrets that I'm sure need to be held. Financial and career implications, immediate financial impact. So he canceled his tours, right? David canceled his tour amid the investigation. Was that the Wither tour? Lost revenue. Tours generate millions for emerging artists. Refund obligations depending on contract terms. Venue deposits may be forfeited, and future booking difficulties now. So venues may blacklist them. Sponsor withdrawals, reports that sponsors dropped him. Endorsement deals typically have moral clauses. Even without criminal charges, association with death investigations trigger these clauses and may have to return advance payments. Streaming and sales. Morbid curiosity may increase streams initially, but radio play will stop. Because remember, his music did go up. I took note of that. Streaming services may remove from playlist and long-term career damage even if cleared. Record labels response. Labels may suspend artists without terminating contract. Wait and see approach. If charged with serious crime, label will drop them. If cleared, label may resume promotion, but damage is already done. Insurance issues. Tour insurance may not cover cancellation due to criminal investigation. Liability insurance if civil lawsuit follows. Rivas' family will sue. Long-term career scenarios. That's financial, so there's a lot there. Long-term career scenarios. If convicted of serious crime, career essentially is over. Music may become dark collectible, but he won't perform again. Prison time means years out of public eye. If cleared completely, attempted comeback possible, but public association with minors' death is career poison. Let's see similar cases where even cleared celebrities never fully recovered. If pleads to lesser charge, for example, concealment or misdemeanor, serves brief jail time or probation, attempts image rehabilitation, career damage potentially salvageable, depends on exact circumstances and public perception. If she died with a drug overdose, but you still concealed the body, I don't think the public's going to have sympathy towards that anyway. I don't. Comparison cases, celebrity death investigation. I did a few. So you had Mac Miller, who in 2018 was a rapper, died of drug overdose. 3 people charged with providing the drugs, charged with distribution of fentanyl, causing death. It's a federal crime. Outcome: all convicted, sentenced to federal prison. Lesson: even if you didn't kill someone, providing fatal drugs is serious felony. And again, if they partied, had a drug overdose, did you give the drugs to the minor? I mean, it's not a good look. Then you had Michael Jackson in 2009. He died of propofol overdose administered by his doctor. Dr. Conrad Murray charged with involuntary manslaughter, convicted and sentenced to 4 years, served 2. Lesson: even licensed doctor can face criminal charges for negligent deaths. Case 3, the Notorious B.I.G., Tupac Shakur. Both murders remain unsolved decades later. Investigations hampered by non-cooperation, destroyed evidence, jurisdictional issues. Lesson: even high-profile cases can go cold. And I'm going to get into cold cases soon because I am concerned about that. And case 4, Phil Spector. Record producer, actress Lana Clarkson found shot in his home. Claimed accidental death. Record producer, Phil Spector. Record producer, actress Lana Clarkson found shot in his home. Claimed accidental death. Prosecutors charged murder. First trial was a mistrial. Second trial convicted of second-degree murder, 19 years to life. Lesson: accidental claims don't always work. Circumstantial evidence can convict. Suge Knight, 2015. Rap mogul. Hit and run, killed 1 person. Initially claimed self-defense accident. Pled no contest to voluntary manslaughter. Sentenced 28 years. Lesson: even without premeditated intent, reckless conduct causing death could equal serious time. Parallels to David's case: young celebrity with rising career, death of someone in their orbit, unclear circumstances, intense media scrutiny, career implication regardless of guilt. So legal team strategy in high-profile cases. Typical defense approaches. Let's see where this goes. So phase 1, information gathering, current phase. Learn what police know, assess strengths of evidence, and decide on cooperation strategy. Phase 2, negotiation if charges seem likely. Proffer meeting with DA, offer favorable narrative or evidence, and try to convince DA not to file charges. So again, this is the defense approach. Next phase for them is damage control if charged. Motion to suppress evidence, challenge search warrant, seek dismissal on technicalities, control media narratives. Guy, that seek dismissal on technicalities, that's getting to me because I watched that interview with that investigator, SF, Stephen Fisher, and you got to see my video. I just did it. But I think there's going to be a concern, minimal, with evidence collection. I think they gave over the house too quick, and you got this guy dropping on the media every little thing that they find. I'm sure it messes with the integrity of the investigation. I mean, everybody loves this guy, I get it, but I did at first too. But as I was watching that video, you could see how all of a sudden I start to get worried about integrity of investigations, which I know very well. And then people message me like, again, he clout chases, he puts himself right in the middle of the narrative, takes control of the story. So I would watch that video that I did yesterday, how I broke down that interview he had on Sidebar, because it's great that we're getting the information, but should he really be giving us that information and evidence that he recovers? You know, I get you're giving it to the PD, but you're also looking at where the owner says they're not, you are. If I was a defense lawyer, I would just be looking for the continuity evidence, and I would just be attacking it. You're still finding evidence in that house after you've already checked. But check out that video. I appreciate it. It's a good video. Me and Russ sat and did a good show on that. But I am concerned about that. And I felt the conflict yesterday, and I just started to get into my feelings because anytime I feel there's a conflict for the justice you need for Celeste, I feel it. And it's like, wait a second, hold on. And I just have to lean in on that feeling and see what's happening in my head, because sometimes you get this, you live life, you know it, and you just got to trust your instincts. Because even if you can't logically put it together, something in your head is telling you something, and you just have to be open to listen to it. So again, with the defense, to negotiate plea deals if evidence is strong, go to trial if winnable or client insists on innocence. Current indicators suggest phase 1 and 2 right now. So no charges filed yet. David's cooperating. Lawyers likely to contact with DA and waiting for autopsy results. So you also got the public relations and crisis mode. So PR strategy for celebrities under investigation. Option A, say nothing, most common. We see that right now. On advice of counsel, no comment, protects legal position, but looks guilty in court of public opinion. But it is what it is. I mean, God forbid you say something wrong and it gets twisted, especially in this narrative. You say one thing, and I just did a video on that. It just gets spread, and everybody puts their own meaning to it, and you have to wind up defending what you said. It's like, you know what, I'd rather not say nothing right now because I don't want nothing twisted. So it makes sense. Limited statement expresses sadness for Rivas's death, pledged cooperation with investigation, do not discuss facts of case. Example, this is tragedy. I'm heartbroken for Celeste's family and cooperating fully with authorities. The only thing funny is if the longer you take to do that, it's going to come out insincere. That's something you would probably expect immediately. So I don't know if that would be a good route. Aggressive denial, which is risky, had nothing to do with this, can backfire if later evidence contradicts it. Only advisable if absolutely certain of innocence. It might have nothing to do with it. That's hard for you to say when the maybe nothing to do with her death, but that you had a relationship with her. He wouldn't be able to get that off. David appears to have chosen option A. No public statement from him personally. Only statements from lawyers or representatives, and only social media presence has gone dark. Reputation management, so scrubbing internet of problematic content, probably too late for that. Monitoring social media to address false rumors, but can't address everything. And then preparing for eventual image rehabilitation if cleared or after serving time. But he's not going to address anything on social media. There's a lot out there, but what do you want him to respond like the manager did? And look what happened. Social media evidence and misinformation. So how social media evidence is actually used in court. I wanted to look this up too, because a lot of this is really being fed through people that follow the case or on social media. And I believe a lot of the information that the investigator gets is because he's on social media all the time. And some of the stuff that he says he discovered or found, it's coming from social media. So kind of adds fuel to the fire a little bit. Because my thing, I want the confirmation from the people that are the real leads in the investigation. Everything else to me is gossip at that point. So how social media evidence is actually used in court, admissibility challenges. So social media evidence is powerful but complex to authenticate. What must be proven is authenticity. The account belongs to a person. The account belongs to a person, the person claimed. Authorship, the specific post was created by that person, not hacked account. Accuracy, the post hasn't been altered or taken out of context. And relevance, the post is relevant to the case. Authentication methods is testimony from account owner. Yes, this is my account and I posted this. Circumstantial evidence, account has person's photos, names, personal information. Digital forensics, metadata showing post came from defendant's IP address device. And platform records, subpoenaed records from Instagram, TikTok, confirming account's ownership. Common defense challenges, my account was hacked. Someone else had access to my phone. That's not what I meant by that post. The screenshot is fake, altered. Why it matters in this case, any post by Rivas about David must be authenticated. Any post by David that seem incriminating must be proven to be genuine. And deleted posts can often be recovered, but require subpoenas. Specific social media evidence being examined right now is Rivas's account. They're looking at Instagram, TikTok, Snapchat. What investigators are looking for is last known activity. When did she last post? Where was she? Location tags. Was she tagging Hollywood locations before her death? Photos with David, evidence of their relationship. Age claims. Did her bio say she was 19, USC student, or any other lie? Direct messages, communication with David and others. Story posts, temporary posts that platforms retain even after 24-hour expiration. And friends or followers. Who was she connected to? Any concerning accounts. Key evidentiary questions is, did she post about planning to meet David? Did she check in at locations that match the timeline? Did her post suggest fear, excitement, plans to run away? And did she communicate with friends about her whereabouts? David's account, what investigators are examining for him is DMs with Rivas. How did they meet? What was the nature of their relationship? Evidence he knew about her age. Remember, guys, I did a great video on the break-in of the parasocial relationship. And this is key on that. I'll definitely check out that video as well. Post around relevant dates. Did he post anything suspicious before or after her death? Deleted content. What did he delete and when? Mass deletion after September 8th is consciousness of guilt. Interaction with others. Did he discuss Rivas with friends or followers? And location data, Instagram, Snapchat, track location history. The romantic homicide music video, public speculation. David had a song called Romantic Homicide. Music video showed blindfolded man and people placing body in trunk. Fans claim this is evidence of premeditation or confession. Reality, the song was released in 2022, 3 years before Rivas' death. Romantic homicide is a metaphor for emotional pain in relationship, not literal murder. Keep on hearing that. Music videos often use dark imagery without connection to real events, and artistic expression is not evidence of criminal intent. That's not going to hold. That's what I'm saying. Everybody's focusing on all this stuff, all this connections through social media. It's just not going to be strong enough on its own. Legal analysis. Prosecutors cannot use song lyrics as evidence of intent. Well-established case law protects artistic expression. However, and we discussed this before, if there are specific details that match the crime, for example, lyrics about putting her in a Tesla trunk in September, that could be admissible. And general themes don't count as evidence. Similar cases, so multiple rappers have been prosecuted in court struggle with whether lyrics are evidence. Growing movement to exclude rap lyrics from trials as unfairly prejudicial and protected speech, and California considering legislation to limit use of creative expression as evidence. And that may move a little forward with this case here. Witness contamination through social media, that's a problem. So once a case goes viral on social media, witness memories become contaminated. How it happens, witnesses see theories online, then their memories conform to what they've seen. False memory creation, people remember details they actually learned from TikTok. Conformity bias, witness change stories to match popular narrative. And attention seeking, some people exaggerate or fabricate to be part of the story. I think there was something with a bodyguard who may have said something, but I don't know if he was the bodyguard or not, but it was just a bunch of BS in the long run. Something with the burying of the body or something, or put in the trunk. I forget. Example in this case, person saw Rivas in Hollywood, California in early September, later sees TikTok theory that she was drugged at a party, now remembers that she looked drugged or unsteady, and his memory is contaminated by suggestions that are not reliable. And guys, I'm sure we see that all the time, right? Oh, maybe she was drugged, because I did see her there. Again, that's hypothetical. Defense attorney's dream, witness whose testimony aligns too perfectly with viral theories and can be impeached on cross-examination. Isn't it true you saw this theory on TikTok before talking to police? Prosecution's nightmare. Key witness gives statement, then changes it after seeing social media. Defense argues witness is unreliable due to contamination. Judge may exclude testimony. Contamination is a real thing. Best practice, often not followed, is police should instruct witnesses not to follow cases on social media. Witnesses should give statements before viewing media coverage, and sequential photo lineups showing suspects one at a time reduce suggestion. That's why social media, hey, do me a favor, if you're my witness, don't follow any of these cases, because that's what, guys, with all this stuff going on social media, all the things that are being said, you could have some people that will be affected by that. And that's a great pull for, hey, you haven't been watching social media, stuff you're saying, maybe you believe that connection is strong based on what you're seeing on the media. Contamination. I object. So that also taints the jury pool. The challenge in high-profile cases, finding impartial jurors is nearly impossible. Jury selection problems. Everyone has heard of the case, so hard to find jurors with no prior knowledge. Preconceived opinions. Jurors may have already decided guilt or innocence based on social media. And hidden bias. Jurors may claim to be impartial but are influenced by what they've seen online. And then there's the voir dire. That says, does that make sense? That's a jury selection process. If you guys know how to say it better than I do, please do. Attorneys question potential jurors about media exposure. Those who admit strong biases are excluded, but many jurors hide their bias to get on the jury. And then you have the change of venue motion. So defense may request trial be moved to different county. Argue that LA County jury pool is too contaminated. Courts rarely grant these. They prefer careful jury selection instead. In this case, if David is charged, his attorney will face massive TikTok, Twitter discussions of the case. Viral theories presenting him as guilty, which is all over the internet now. Graphic details and photos circulated online. And strong emotions about young girls' deaths. Defense strategy, extensive jury questionnaire asking about social media usage. Challenges for cause, removing obviously biased jurors. Preemptory challenges, limited members of removals without stated reason. and jury instruction to ignore outside information. So the platform cooperation with law enforcement, how quickly platforms respond to legal request, emergency request, imminent danger. Law enforcement can request immediate data without warrant. Platforms may comply within hours, limited to basic information. Search warrant, which is most common. Formal legal process requiring judge approval, served on platforms electronically. Response time varies. For Meta, Instagram, or Facebook, it looks like it's usually 2 to 6 weeks. Snapchat is 1 to 4 weeks, but limited data retention. TikTok is 2 to 8 weeks, improving cooperation with U.S. law enforcement, so they're working better. Twitter, it varies, but 1 to 6 weeks. Google, which is YouTube, is 2 to 6 weeks. What platforms provide? They will provide account registration information, email, phone, IP addresses, login history, dates, time, locations, posted content, photos, videos, messages, deleted content if still retained on servers, and metadata when content was created, edited, deleted. What platforms don't provide? Snapchat, messages disappear from servers, though may be recoverable from individual phones. Encrypted message, end-to-end encryption, WhatsApp, Signal, can't be decrypted by platform. And very old data, retention periods vary. Some data deleted permanently after 30 to 90 days. In this case, LAPD has certainly subpoenaed Instagram, TikTok, Snapchat, and etc. They're likely still waiting for full data dumps, and this is part of why investigation is taking so long. So we know it, we see it, or we think we know it, but they're going through the process to make sure they can confirm everything. So you may see things on the media and think, well, why didn't they take that? Why didn't they? Is it authenticated? Did we get stuff from the proper authorities so we can go ahead and lean on them and say this has gone through them? Because we'll get challenged. Oh, the detective pulled that up himself. Oh, he wasn't given it by whatever platform company. Well, then irrelevant. We don't want it. Objection. So digital lynch mobs and this is the defamation. The phenomenon. Social media users conduct investigations and publicly accuse individuals. What's happening in this case? TikTok users created theories about who's responsible. Some accuse David's managers, friends, associates. Others accuse completely uninvolved people based on misidentified photos and viral posts with millions of views spreading unverified claims. Legal consequences for accusers. Defamation law, so libel, written, or slander, which is spoken. So libels, written, slander, spoken. False statements that harm someone's reputation. Elements: 1, false statement of fact. 2, published to third party. 3, causes harm. 4, made with fault. So negligence or malice. Defenses: truth. So if statement is true, it's not defamation. It's harmful. Even if it hurts you, it's not defamation. It's true. Opinion: pure opinion is protected. I think he did it versus he murdered her. And public figure: if target is public figure, must prove actual malice, knowing, falsity, or reckless disregard. Who can be sued? TikTokers or YouTubers. If they make false accusations, they can be sued. Commenters, even individual users can be sued through, though less common. And platforms, generally immune under Section 230, but platforms are not liable for user content. They can't control every comment that comes through or the content that's being made. I mean, they put all these measures in place, but they're not perfect. Stuff gets past them still. Practical realities: most accusers have no asset worth suing for. Lawsuits are expensive and take years. Many accusers hide behind being anonymous, and damage is often done before a lawsuit can proceed. Example cases: I saw Richard Jewell falsely accused of Atlanta Olympic bombing by media, eventually won defamation suits. Reddit Boston Marathon bombing, users falsely identified suspects. Some did face consequences. And YouTube true crime channels, several have been sued for defamatory accusations. That's why I try to keep things objective. Protection strategies: platforms can ban users for harassment. Individuals can send cease and desist letters, and in extreme cases, restraining orders for harassment. Misinformation management by law enforcement. All right, now this is important to me, guys. I want to go into this, and I have we're almost done, guys. I know there's a lot here, but I'm trying to answer the question. It's not such an easy question. Why he can't be charged? I have to try to give you every angle. It's just who I am, and in the process, I learn. So at least, if anything, I learned a lot through this little session or long session. So misinformation management by law enforcement. That's what we're going through now. That's a dilemma, right? Police must balance investigative secrecy. Don't reveal evidence that could compromise case, SF. He just gives enough. But he shouldn't be. He's not the lead on the investigation. I'm sorry, it's just getting to me right now. Maybe I'm wrong, but something I feel. Public information community has right to know about threats or crimes. So again, they do if there's an actual threat that's coming their way right now. But rumor control, false information can derail investigation. So options. Option 1, say nothing. Current LAPD approach. That's the goal, right? Pros, protects investigation, avoids revealing evidence. Cons, vacuums filled with speculation, public frustration. And you'll notice that, guys, like, oh my God, where the hell is this going? Man, they're going to run with this. They're going to run with this if this gets released. So don't throw it out yet, because we're not ready to kind of keep the narrative where it needs to go. So if you throw that out too soon, it's going to run out, and then we're going to have to force to say something. So sometimes you have to control what goes out there. You could see it with SF. He drops stuff out, and then everybody runs this speculation, and someone's like, hey, we weren't ready to release that yet. Because what we're setting to counter that is still in the works. Option 2, regular press briefings, and we see that when they're more confident. Control narrative, corrects misinformation, and may reveal too much, creates pressure. Pro is controls narrative, corrects misinformation, but the con is may reveal too much, creates pressure to share info prematurely. So it's very controlled. But you do see some that really do go with the press conferences, and they get stuff that needs to get out there, but stuff they hold on to because it keeps with the integrity of the investigation. Option 3, you engage directly with social media. Pros can quickly correct false rumors, but cons legitimize social media speculations, and you just can't address everything. LAPD's approach in this case, minimal statements, death investigation ongoing, refusing to answer specific questions, emphasizing that speculation is inappropriate. And why this approach? They don't want to reveal cause of death before autopsy is complete, don't want to tip off suspects about what police know, and don't want to create false expectations about arrests. Problems with this approach: allows misinformation to flourish, public perceives lack of transparency, and media fills void with speculation. Covered that. Did a whole 2-hour video on that. Trial by social media, the danger: even before any charges are filed, public has convicted David online. How it works: incident occurs, body discovered, speculation begins within hours, the theories emerge, viral spreads. Most sensational theories get millions of views. Most sensationalized theories get millions of views. That's on us because we're watching it. Confirmation bias: people seek evidence supporting their theory, ignore contradictions. Guys, I've seen that with the run with Celeste Rivas Hernandez here. Some of the podcasts I was watching, when people started to shift and put the blame on her or her family, all of a sudden the people shifted, the ones that were watching. Oh, kids only run away for 2 things: because of mental health concerns or because of bad families. What are you talking about? Most of the time they run away is because they're probably chasing love. They're being lured. And then mob certainty: within days, masses are certain of guilt despite no trial. Why is this dangerous? Because it's the presumption of innocence is constitutional right, but social media doesn't follow it. Due process requires formal charges, evidence, trials. Social media just skips all of that. Irreversible harm: even if later cleared, reputation is destroyed, and justice system compromise affects ability to get fair trial. And that was my big concern recently. Historical parallels before social media: so public lynching, mob justice based on accusations, no different. With newspapers, yellow journalism, convicted people to print before trials. Because it's not even so much to get the story out first, but rather to control the narrative. And then it's funny because when the narrative strays a little bit, then you'll get maybe other agencies that want to kind of continue that spin, but they will always know, by the way, we're getting this from this. So if something does hit the fan, it's like everybody's falling on this one source who's created a bullshit narrative. With TV, high-profile cases, high-profile trials became media circuses like O.J. Simpson or Casey Anthony. And with social media, amplified 1,000 times faster, more distributed, no editorial control. What should happen versus what does happen? Well, what should happen is police investigate quietly. Evidence is gathered professionally. If sufficient evidence, charges filed. Public trial with defense attorney and rules of evidence, and jury decides guilt or innocence based only on admissible evidence. Verdict is rendered. What actually happens right now is incident becomes public immediately. Social media investigates based on fragments of information. Theories go viral before police even process evidence. Public convicts based on speculation or artistic expression vibes. And when trial eventually occurs, if ever, jury pool is contaminated. Solutions that should be out there are gag orders. Judge prohibits parties from discussing case publicly, rarely granted pre-charge, but that's why maybe he could talk a little bit more freely. But if there is a charge that starts to get served, you got to be quiet now. So you may see a lot less of the investigator. But right now, there's no charge. Social media restrictions, some, of course, because at that point when you charge, you don't want to contaminate. You got to, again, protect the integrity of the investigation. Social media restriction, and both parties, the defense and the prosecution. Social media restrictions. Some courts limit what can be said online. That's enforcement, but that's extremely difficult. Media literacy education, teaching public about presumption of innocence, which is just ineffective right now. Platform moderation. So social media companies removing harmful speculation, but there's free speech concerns with that. And the First Amendment problem. Americans have right to discuss public figures and matters of public interest. Can't prohibit people from theorizing about crime, and only actionable statements are defamatory, and even then, hard to prove. All right, guys, we got a little more jurisdictional complexity. And the reason why I'm doing all this is because, believe it or not, the search for why people aren't charged creates a lot of rumor mill. So hopefully this answers some of these questions. So where did death occur? That's the complexity. This is the critical jurisdictional question. Scenario A, death occurred in LA County, Hollywood. LAPD has jurisdiction. LA County DA would prosecute. LA County Superior Court would hold trial. Scenario B, death occurred in Riverside County, Lake Elsinore area. Riverside County Sheriff has jurisdiction. Riverside County DA would prosecute, but body was found in LA County. That's a concern. But scenario C, death occurred somewhere else entirely. Wherever death occurred has jurisdiction, but where body was found, let's say in LA, also has involvement. So why it matters, the venue. Trial must be held in county where crime occurred. Resources. Different counties have different budget expertise. Different budgets and expertise, sorry. So different counties have different budgets or expertise. Prosecutors, different DAs, offices, different priorities. Evidence, if death occurred in one county, but body found in another, evidence split between both jurisdictions. How investigators determine death location, medical evidence, lividity. So blood settling in body after death shows position body was in. If position doesn't match where found, body was moved. Rigor mortis, stiffening of body, timing, helps establish when death occurred. And etymology, that's the bug. So insects on body can indicate environment where death occurred. If body was inside at death, certain insects, let's do this again. Insects on body can indicate environment where death occurred. If body was inside at death, certain insects. If outside, different insects. On the body, inside the body, outside the body. Forensic pathology, injuries, cause of death may indicate type of location. Physical evidence. Trace evidence on body, fibers, soil, pollen can indicate where death occurred. Contents of stomach, if she ate specific food shortly before death, can be traced to restaurants or locations. And phone records, last known location before phone went dead. Witness statements, where was she last seen alive? Where was the car at the time of death? Did anyone see, hear anything at suspected death location? And then in this case, Rivas lived in Lake Elsinore. Body found in Hollywood, LA County. David has residence in Hollywood, LA County. Most likely scenario, death occurred at David Hollywood residence. Then body was placed in Tesla. Right now, that's still up to speculation because unconfirmed, but the investigator says that he has no reason to believe she was on the property. And maybe he's right, but he also works for the owner of the property. If this scenario is correct, It's not an attack, SF. If you watch these, I doubt you do watch my stuff, but I don't want to mess this up. It's not about you. It's about her. At this scenario, if this scenario is correct, let's see. No, I got to show a picture again. All right, so where was I? So the most likely scenario, death occurred at David's Hollywood residence, and the body was placed in Tesla. All right, so if this scenario is correct, LAPD has primary jurisdiction. Death occurred in LA County. Riverside County Sheriff involved as assisting agency. Victim was their resident. LA County DA would prosecute. Multi-agency coordination. Agencies likely involved. So you have the Los Angeles Police Department, which we know of, primary investigative agency, robbery homicide division handling case, elite unit for high-profile murders, served search warrant at Hollywood Hills residence, processing forensic evidence, and interviewing witnesses in LA County. Riverside County Sheriff's Department's agency where Rivas was reported as runaway previously, has background on her history, family, prior incidents, may have investigated her previous disappearances, likely provide historical context to LAPD, and may interview family members and Lake Elsinore witnesses. Los Angeles County Medical Examiner coroners performed autopsy, conducting toxicology tests, will issue final determination of cause and manner of death, and their findings will drive prosecution decisions. Los Angeles County District Attorney's Office will make charging decisions, working with LAPD to assess evidence, maybe conducting independent investigations, and ultimately decide what charges to file, if any. And FBI possibly may be involved if interstate trafficking suspected, can assist with digital forensics, has resources for complex cases, and not clear if involved in this case, but possible. Imagine she went to his home in Texas at any point on that private jet, if she was ever on the private jet. She went to any of his tours. Could that be trafficking a minor? Especially if they're having sex. They got to prove it. Coordination challenges, different computer systems. Each agency has its own database. Information doesn't automatically sync, and must manually share reports or evidence. Different priorities. LAPD focused on homicide in their jurisdiction. Riverside's focused on missing person. That's a missing person case in their jurisdiction. And they may not realize they were working related cases until body was discovered. Territorial issues. Agencies sometimes compete rather than cooperate. Credit for solving cases, of course, media attention, promotions, and it can lead to inefficiencies and duplicate efforts or hiding information if they're competing. Evidence sharing must establish protocols for who has custody of evidence. Chain of custody must be maintained across agencies, and that's another thing. If you got Riverside County involved and could be assisting, and then you got LAPD, and then you got this guy in the middle, the investigator. He's in the middle. And lab results must be distributed to all relevant agencies. Because as I said right before, a chain of custody must be maintained across agencies. Witness coordination. If witness interviewed by multiple agencies, statements must be consistent. Different interviewers may get different information and must avoid re-traumatizing witnesses with repeated interviews. Venues for trial, where case could be prosecuted. I'm covering everything, guys. So general rule, trial held where crime occurred. So California Penal Code and it's S777. When the commission of a public offense commenced without the state. When the commission of a public offense commenced without the state is consummated within its boundaries, the defendant is liable to punishment therefore in this state. Though he was out of state at the time of the commission of the act commenced, and the trial shall be in the county where the offense is consummated. Translation: trial occurs in the county where the crime was completed. Application to this case: if death occurred in LA County, trial in LA County Superior Court, most likely venue, criminal courts building in downtown LA, and jury pool from LA County, population of 10 million. If death occurred in Riverside County, trial in Riverside County Superior Court, jury pool from Riverside County is a population of 2.4 million, and different legal culture, more conservative, potentially harsher on defendants. If death location is unclear, prosecutors may have discretion to file in either county, usually choose venue most favorable to prosecution. Defense can challenge venue choice. Change of venue motion. Defense may request trial to be moved to different county if pretrial publicity makes fair trial impossible, community bias against defendant, and threat to safety, mob violence concerns. Standard for grant and change of venue must show reasonable likelihood defendant can't get fair trial. Very high bar. Courts prefer careful jury selection over moving trial. And even if most notorious cases, change of venue rarely granted. Historical examples, we have O.J. Simpson stayed in L.A. despite massive publicity. Scott Peterson moved from Stanislaus County to San Mateo County due to publicity. And Timothy McVeigh, Oklahoma City bomber, moved from Oklahoma to Colorado. If David's charged, his attorney will likely request change of venue, will cite social media frenzy, viral videos, millions of views on theories, will argue impossible to find impartial jury in L.A. Prosecution will oppose. Jury selection can overcome bias. Judge will likely deny. Modern voir dire, that word can identify biased jurors. Practical reality, case will almost certainly stay in LA County. Jury selection will take weeks with extensive questioning to try to avoid the bias. Selected jurors will be instructed to avoid all media coverage, and alternate jurors selected in case seated jurors are exposed to outside information. I can see this definitely being closed off. Evidence sharing between jurisdictions, a challenge. Evidence is scattered across multiple counties. Evidence in LA County, the Tesla vehicle, that's physical evidence. The body, which is examined by LA County coroner. David's Hollywood residence, search warrant executed. Scene where car was parked, that's Hollywood Street. And tow yard where body is discovered. Evidence in Riverside County, Rivas' home and personal belongings, or school records, family interviews, reports from previous runaway incidences, friends and witnesses in Lake Elsinore. Digital evidence, so there's no physical location, but phone records held by carriers, social media data held by platforms, cloud storage, various servers nationwide. Coordination requirements, so for formal agreement, agencies establish memorandums of understanding, MOUs, define roles, responsibilities, and information sharing protocols. Lead agencies, LAPD appears to be the lead, so that's the Robbery Homicide Division. Other agencies in supporting roles, and all evidence flows to lead agency. And again, who's SF in this? Look at all the resources we have. And if they're not releasing anything, I mean, he's filling the gap because the public wants to know, but maybe the public doesn't have the right to know just yet. I mean, I doubt they need his help. They have all this. But we may feel that they need it because they're not answering questions, they're not saying anything, but that doesn't mean they don't know what they're doing. They're just, look at all the stuff in play here, why there's no charges yet. Because the lead agency is LAPD, Homicide Division. Joint Task Force may establish formal task force with representatives from each agency. I see that happening a lot. When you have too many working together, they try to get something joint. Meet regularly to share information, coordinate investigative steps. Digital evidence management, usually one agency takes lead on digital forensics. Results shared with all agencies through a secure portal, and must maintain strict chain of custody. Must maintain strict chain of custody. I discussed this during the show yesterday. Discovery obligations. Once charges are filed, prosecutors must provide all evidence to defense. Brady material, so exculpatory evidence. So that's why I'm saying you have to also provide the other side. So even though I don't think it's going to hold weight, she said she was 19. Let me show you where it is. It was on social media. It was on this, but also didn't say she was 19 on social media. It didn't say, this one discovered it. So it goes both ways, but you should provide both. Shows the investigation was done objectively, because the defense is expecting the investigation to be done objectively. That's part of their argument. So it's good if you know that stuff exists, that it's not brought out by them. But just prepare to defend it, whatever you bring out. Witness statements, forensic reports, photos, and videos, and challenge evidence held by multiple agencies must all be collected and disclosed. Risk that something gets overlooked. We don't want that. And defense can move to dismiss if exculpatory evidence is withheld. And that's what I'm saying. You don't want them to discover it, and then you have it. Interstate issues. If investigation reveals interstate activity, possible interstate elements. Rivas communicated with David across state lines. He has a Texas connection. Phone calls or messages across state lines could involve federal wire fraud statutes. If she was transported across state lines for legal purposes, that's the Mann Act. Same thing you saw with P. Diddy. And if David fled to another state to avoid prosecution. Federal jurisdiction could attach Mann Act violation, transporting minor across state lines for prostitution or illegal sexual activity, which if they were sexually active. Sex trafficking using interstate commerce, internet phones to recruit minors. It's on the phone with her, talking to her. Wire fraud using phones, internet to commit fraud across state lines, and interstate flight. Fleeing to another state to avoid prosecution makes it a federal crime. Why federal charges matter? Federal sentences often longer than state. Federal prosecutors have more resources. No parole in federal systems. They have to serve 85% of their sentence, and may be strategic. Feds step in when state case is weak. Current indicators, no indication of federal involvement yet. This appears to be purely state-level investigation, and unless trafficking or interstate flight develops, likely stays a state case. Now, I want to do victimology and risk factors. This is important. So, Celeste Rivas' life and background, because again, I've done videos on this, but I want to reiterate again, because you never know, someone new could be coming to the channel. Eventually, you saw in the media how they started switching and just kind of putting everything towards Celeste Rivas, her family, her, and they took attention off of David and areas where he should be held accountable. So what we know is confirmed. Okay, so this is what we know. Most likely 14-year-old at the time of death, but she's marked as 15-year-old because that's when they discovered her body. So right now, they're going to say 15 years old at the time of death because that's when they discovered the body, and they don't have how or when she actually died. So that's what they have. Lived in Lake Elsinore, Riverside County. Attended school there, 7th or 8th grade. Sources vary. Run away from home multiple times in 2024. Not pregnant, contrary to early rumors. And found deceased in a Tesla in Hollywood, 90 miles from home. What we don't know, but investigators are examining, is family dynamic, relationship with parents, siblings, home environments, school performance, attendance, grades, behavioral issues, mental health history, depression, anxiety, trauma, substance use, any known drug or alcohol use, social circles, who were her friends, what were her activities, online presence, what did her digital life reveal about her state of mind, and prior contacts with adults. Had she previously been in relationships with older adults, older individuals, or another person whose name is mentioned with her too. How a 15-year-old connects with music artists. Typical grooming patterns. Phase 1, initial contact. And guys, this is the parasocial relationship. I did a whole video on this. Highly recommend you watch it, but I'll speed through it here. So social media is primary vector. So Instagram, TikTok, Discord, Snapchat, whatever. Young fans reach out to artists they admire. Most artists ignore or politely respond. Some predatory individuals engage and begin grooming. That's the parasocial collapse right there. Phase 2, building trust. Predators show special interest. Oh, you're so mature for your age. Provides attention and validation. You're different from other fans. Shares personal information to create false intimacy. And then gradually normalizes inappropriate conversation. Isolation. This is the runaway part, the luring. Encourages victims to keep communication secret. Creates narratives that others won't understand their connection. So, hey, people aren't going to understand. I know you're young. We really shouldn't, but they don't know how mature you are. And they don't understand what we have. May portray themselves as victims only. May portray themselves as victims only true supporters. So basically, I mean, she's constantly running away with me supporting her, but also supporting her mentally. You know, she's vulnerable. Even if it's just simple. I hate the rule. I'm in trouble home. Why? Oh, they wouldn't let me go to your concert. I'll help you with that. Doesn't mean her family's trouble. They're just setting a rule. But he becomes the hero. Sexualization. Gradually introduces sexual content, may request photos or videos, arranges in-person meetings, exploits victims' trust and attachment. Then you got the control, uses shame, fear, or affection to maintain control. That's why she kept running back to him. May provide drugs, alcohol, money, or gifts. Superficial, but it works. Especially if she's already vulnerable in those areas. Victim becomes dependent on predator and difficult for victim to extricate themselves. And they'll defend them too. They'll defend them. And it's not her fault. He's the adult. In Rivas' case, investigators are examining how did she first connect with David? DM on Instagram, at a concert, through mutual friends. How long had they been in contact? What was the nature of their communication? Did David use grooming tactics? And how did she travel in Hollywood? Did he pay for transportation? Come pick her up? Or did she come on her own? On her own. And there's reason to believe he may have even picked her up. There's a video that they show when she was by the across from the liquor store. They believe she went into a vehicle. It's just not shown, but that's what the owner of the store said. That was around, February, March. It was March. Digital footprint analysis. What investigators are reconstructing, social media behavior, right? So when did her online behavior change? New accounts created to hide activity from parents. Changes to who she followed or interacted with. Posts suggesting plans to meet someone or go somewhere. And evidence of lying about age or identity. Communication patterns, frequency of contact with David, daily, weekly, time of day, late night, suggest hiding from parents. Content of messages, affectionate, sexual, fearful, and deleted messages or apps suggest concealment. Location data, had she been in Hollywood before? Phone location history showing previous trips. Check-ins or geotag posts from relevant locations. And search history. What was she searching for? Information about David, how to run away, travel to LA. Any concerning searches like drugs, self-harm, risky behavior. Financial activity. Any unusual purchases or money transfers, gift from adults, evidence of being paid for anything. School and family situations, questions investigators are asking. So family dynamic. This is, again, not to minimize his role. That's why I put grooming first, but you still got to know it. So who did she live with? Both parents, single parents, guardians, relationship quality with parents or guardians, any history of abuse, neglect, or CPS involvement, siblings and their relationships, family aware of her online activities. School performance, attendance, was she frequently absent? Runaways would cause absences. Academic performance, good student or struggling, behavioral issues, discipline problems at school, whatever. Social integration, did she have friends? Was she isolated or bullied? And teacher observations, did teachers notice warning signs? Red flags, educators should have noticed, because again, it is a community. Your teachers do know your children. They also know what's trending. They're in that environment. Chronic absenteeism, so that's running away, changes in behavior or mood, inappropriate relationships with adults, unexplained gifts or money, secretive about phone or online activity, and withdrawal from previously enjoyed activities. Because they're amongst the kids, they see it. Just trust me, that's what kids are going to do with social status. That's why maybe to her parents, they only knew who David. But for social status, she told her friends who David was. Mandated reporting obligations. California teachers, counselors, and school staff must report suspected child abuse or neglect. We talked on that. Child under 16 having sexual contact with adults and knowledge of child being endangered. If school staff noticed warning signs and didn't report, they violated mandatory reporting laws, could face criminal misdemeanor charges, and could be sued civilly by Rivas' family, and school district could face liability. The teacher's video raises questions about what school knew. Did teachers report concerns before Rivas' death, or did teachers only realize significance after the fact? And will be critical issue if family sues school district. Interesting. If I saw that video and I was a family, I would look into that. Previous contact with adults, pattern analysis. If Rivas had a history of relationship with older individuals, it would suggest she was vulnerable to exploitation. She may have been seeking validation, attention that adults provided. Previous adults may have groomed her to accept such relationships as normal, and traffickers or predators may have been targeting her. Investigators are looking for prior police reports, were there previous incidences where she was found with adults, social media history, evidence of contact with multiple older men, friend statements, did she talk about having older boyfriends, and family knowledge, were parents aware of previous concerning relationships. They just said David. They didn't say anything about his age or what he did. I mean, I'm not saying they don't know, but I would be shocked if they did. The chronic runaway risk factor. Statistics are on runaway youth. So 1 in 7 youth between ages 10 to 18 will run away. Within 48 hours of running away, 1 in 3 youths will be approached by a trafficker. Look at that number. Runaway and homeless youths are prime targets for exploitation, and many eventually become involved in survival sex. So trafficking sex for shelter, food, or drugs. Why? And I remember I dealt with a female prison, and they would say they learn to sexualize real quick because their survival depends on it. Why runaways are targeted: desperate for food, shelter, or acceptance, often fleeing abuse at home, vulnerable to anyone offering care. They have substance abuse issues, making them easier to control. That's important. So if you want to push the blame that, hey, she had this or that, Okay, and you took advantage of it. Because if she was to, let's say hypothetically, she ran to me, I'd be calling the police. I'd be calling CPS. I'd be calling somebody. But I would make it known that this is where she is and I need help. What if those calls were made? How many times, if those were concerns, and you knew about those concerns, okay, did you call CPS or did you call the police? But she's still at your house. Let's see again. So substance issues make them easier to control. Disconnected from support systems, family, school, social services, and often have trauma history, making them easier to manipulate. So if Rivas fits this pattern, she was extremely high risk. Social services and police should have intervened more aggressively. Each time she was found and returned home, thorough assessment should have been done, which we don't know, and failure to protect her may constitute systemic negligence. Mental health, and so I have to put it in mental health and substance abuse history. So common factors in youth who run away repeatedly. So mental health issues, depression and anxiety, PTSD from trauma or abuse, attachment disorder, borderline personality disorder, ADHD, or other behavioral disorders. We did the grooming, so we did get that. I put that at the top. Substance use, self-medicating for mental health issues, introduced to drugs by peers or adults, and using drugs provided by exploiters to maintain control. Trauma history, physical or sexual abuse at home, witnessing domestic violence, loss of parent or loved one, bullying or victimization. Why this matters for investigations: if Rivas had documented mental health issues, may explain her risk-taking behavior, may have made her more vulnerable to manipulation, so I'm going to use that angle, and could be relevant to cause of death if suicide or accidental overdose. So that doesn't matter in this context. If she had substance use issues, increases likelihood of toxicology will show drugs, may indicate she was seeking drugs from David or others, and could support accidental overdose theory. Discovery of these issues will be medical records if family provides to investigators, school counseling records, therapy records if she was in treatment, prescription records if she was medicated, and social media posts suggesting mental health struggles. So let's do a summary of the victimology. So the profile. So investigators create detailed victim profile to understand how she came into contact with suspect, vulnerable victims sought out by predator, or more mutual interaction, but either way, still accountable. Why she was susceptible. What made her a target? What her state of mind was. Was she happy, depressed, or fearful? And whether she was in danger before this incident. Was death culmination of ongoing exploitation or isolated incident? In Rivas's case, the profile likely shows vulnerable teenage girl, history of running away, seeking something not provided at home, drawn to older person, celebrity for validation, possibly misrepresented her age to seem more mature as an adult, engaged in risky behavior, traveling alone to meet adult man, and tragically ended up dead in circumstances still being determined. This profile helps investigators understand how death occurred, assess the culpability of defendant, determine appropriate charges, present compelling case to jury, and advocate for justice of victim. Last part, the cold case prevention strategy. I have a concern here that this could become a cold case. I'm not 100% leaning towards that, but it has crossed my mind. And maybe I'm caught up in the delay. But now after reading this, we're still in the process. We're still not at that point yet. We still haven't gotten the toxicology report yet. But, if it still can't be determined, it could lead to that. So there's some prevention strategies here that I wanted to kind of discuss. I think this is will be interesting for us to go through. So I wanted to add, and I think this will close us off. So the current case status, open and active investigation. So police are still actively working leads. Evidence is being processed. Witnesses are being interviewed. Case has not gone cold. When does the case go cold? Typical definition: no new leads for 6 months. All known evidence has been processed. Witnesses have been exhausted. No suspects identified or insufficient evidence to charge. And hold on, the case remains open but not actively worked. So current timeline for Rivas's case: body discovered September 8th of 2025. Current date today is October 18th, 2025, and that's what I have here. Elapsed time is only 6 weeks. So again, we're within that range of still got about last time was 6 weeks. I actually said it was a month. Where did I get the month from? Oh, because of when they said who she was. So technically we're in that 6 week mark. I apologize. What I said at the very beginning, my time frame was a bit off. So we should be getting something, I would say, within the next, hopefully very soon. And if we don't, maybe there's just circumstances right now that require a little longer to get the answers that we need. And this is still early in an investigation, so not a cold case yet. Critical early action, what LAPD is doing now. So time-sensitive evidence collection. So that's physical evidence because that degrades rapidly. So body recovered and autopsy performed. That's checked. That's done. Vehicle impounded and forensically examined. Done. Crime scene, if any, secured and processed. Presumably, I put presumably done because you got this guy going back and forth through the crime scene, which is a very big concern for me. Toxicology result that's pending. It takes weeks and months. Sorry about my earlier time frame was off. I just went from a different date. DNA analysis that's pending, and that can take months. And digital forensics is ongoing, and that also could take months. All right, so then the witness interviews, because memories do fade. So families interviewed, done, probably Riverside County. Friends interviewed, likely done. Acquaintances and peripheral witnesses, I think that's still ongoing. And re-interviews as new information emerges, I would assume that's still ongoing. Electronic evidence can be lost, right? So phones and computers seized, done, and a search warrant. That was on the 17th of September. Data extraction analysis, that's always going to be ongoing right now. Social media subpoenas probably ongoing. Cloud data recovery ongoing. And cell tower records probably ongoing. They're probably in the process of trying to get the approval after the subpoena. Get the company to get the stuff to them. Because we said each one has a certain time frame on average. Surveillance video, often deleted after 30 to 90 days. So again, canvas areas where a car was parked. I think that's done. Obtain videos from business, which is time sensitive, but there's just housing locations. And then traffic cameras, ATMs, etc. And that must be requested quickly. We had an article that came out that just confirmed that the police had all the videos, which we kind of knew. But that article came out from TMZ, so we could assume they're just probably reviewing it all because probably a lot. I mean, you're looking at that just that time frame alone, so at least they know when the car was there and the body when the car got moved, so they know within that window. But they got to look at before too. What could make this case go cold? I have to put this in here. Besides people messing with evidence, because that's not really cold. Just it means you can't hold anybody accountable. But to me, if there's no closure, it's almost similar to being cold. But okay, so autopsy is inconclusive. Toxicology can't determine cause of death. Too much decomposition. Medical examiners list manner as undetermined and result without knowing how she died. Can't prove who killed her, if anyone. I know there's a battle right now with that Ellen Greenberg. They want the undetermined or the homicide, and they, after another review, it was a suicide again. Maybe there's something there that we don't see. Lack of physical evidence. So scenario 2 would be lack of physical evidence. No DNA linking suspects to crime. No witness to death. No surveillance video showing relevant events. Result, circumstantial case only, may be insufficient for charges. Scenario 3, digital evidence doesn't provide answers. Phones, computers encrypted and can't be accessed. Messages deleted and unrecoverable. No incriminated searches or communication. Result, can't reconstruct timeline or prove knowledge or intent. Scenario 4, witnesses are not cooperative. David asserts Fifth Amendment rights, says nothing. Associates refuse to cooperate. No one admits to seeing anything, and results, no testimony to build case around. Scenario 5, multiple suspects, can't determine who. Evidence suggests multiple people involved, can't prove which one caused death, because a lot of people have motive. Each blames the other. Result, insufficient evidence to charge anyone. Scenario 6, accidental death with concealment only. Death determined to be accidental, overdose, medical event. Concealment is the only crime you got. That's a misdemeanor. And DA declines to prosecute misdemeanor in high-profile cases. Result, case closed without charges. The cold case prevention strategies being employed. Strategy 1, multi-agency coordination. LAPD coordinate with Riverside County, FBI, etc. Ensures all evidence is collected and shared. Multiple experts reviewing evidence. That's my concern here. Watch my video I did when we talk about the investigate. Don't let our want for answers mess with what needs to be done. Because people will start coming out of the woodwork and they could be in positions where they know and they're just giving out information. I would be very upset with that. Forensic excellence, using best available technology for evidence processing, sending evidence to top labs and consulting experts in various fields, so toxicology, entomology, digital forensics, etc. Strategy 3, witness protection and encouragement, protecting witnesses who may fear retaliation, offering immunity or plea deals to get cooperation, and re-interviewing witnesses as new information emerges. So the follow-ups. Media management, controlled release of information to maintain public interest. Soliciting tips from public and using media pressure to encourage witnesses to come forward. But it should be controlled release of information because there's a strategy behind that release. It's controlled. So when you release something, you get ahead of what could possibly be asked and not allow for the rumor mill to be spread. Again, if you're not ready for the information to get released, don't release it. Because in the end, you got to be prepared for all the questions that could stir up from the rumor mill. Strategy 5, detailed reports of every investigative step, preserving all evidence properly, video, audio, recording interviews, and purpose if case does go cold, future investigators have complete records. That would be important. Strategy 6, consultation with prosecutors early, DA's office involved from beginning, ensures evidence collected meets legal standards, and prosecutors can advise on what additional evidence is needed. And again, that also relates to that guy in the middle. Strategy 7, use of technology, DNA database, CODIS, facial recognition, license plate readers, cell phone forensics, and social media analysis. And again, it's not an attack on the investigator. I know people like them, but I got the integrity of the case. I'm talking to someone who's messaging me during this time or commenting through the YouTube channel. And to be honest with you, it's really about her memory, trying to create a bigger impact because maybe there's something here we could do under her name for runaways, even if it's better grooming laws or whatever we could do so this doesn't happen again, or better prevention measures, but also so the family doesn't get destroyed in the process by us because we're jumping on rumor mills. So if case does not go cold, what happens next? So inactive status, case remains technically open, but no detective actively working on it, file stored for future review. Periodic review, cold case units review inactive cases. New technology may allow re-examination of evidence. Tips from public can reactivate investigations. Example of cold cases solved years later. You have the Golden State Killer, Joseph DeAngelo, crimes committed between 1970s and 80s. Case cold for decades and solved in 2018 using genetic genealogy. DNA matched to family members in public database. Less than DNA technology advances can solve old cases. And then BTK Killer. Dennis Rader. Murders committed around the 70s and the 90s. Case cold for years. Solved in 2005 when killer reemerged and sent letters to police. Metadata on floppy disk led to his church computer. Lesson killers sometimes can't resist resurfacing. John Benet Ramsey, murdered 1996. Case still cold almost 30 years later. Despite massive investigation, never solved. Lesson, some cases remain unsolved forever, despite best effort. Technology that could solve this case in the future. If cases go cold now, these technologies might solve it later. Genetic genealogy. If DNA is recovered but doesn't match anyone in CODIS, you can use public genealogy databases. I got like 23andMe and Ancestry.com to find relatives. Build family tree to identify suspects and use to solve dozens of cold cases in recent years. You have advanced digital forensics, ability to crack phones, encryption's improving, better tools for recovering deleted data, and AI-powered analysis of massive data. Facial recognition, if there's video of unknown persons, database improving constantly, can identify people from partial or obscured faces. Social media mining, AI tools can analyze billions of social media posts, can find connections between people, and can locate witnesses who haven't come forward, and improve toxicology. New tests can detect substances previously undetectable, can test smaller samples, and can distinguish between antemortem and postmortem drug presence. California, there's no statute or limitation for murder. The legal framework, as we mentioned before, California Penal Code S799, prosecution for murder may be commenced at any time. What this means is murder can be charged 1 year, 10 years, 50 years after the crime. Prosecution never expires. Even if case goes cold for decades, charges can still be filed. Why this matter? Takes pressure off investigators we talked about, allows time for forensic results, new technology, witnesses to come forward, and ensures justice can be served no matter how long it takes. But there are practical problems. Witnesses die or become unavailable. Memories fade over time. Evidence degrades, and defense is prejudiced by delay. Harder to mount defense decades later. Other charges do have statutes of limitation. Manslaughter, we talked about 6 years. Child endangerment, 6 years. Statutory rape, which is a felony, is 10 years. Concealment of death, 1 year. Strategic timing issue. If this is not murder but a lesser charge, prosecutors must file within statute of limitation period. If they wait too long, hoping to build murder cases, they may lose ability to charge at all. Talked about that before. I got some warning signs that this case may become cold. Indicators to watch for. Sign 1, long delay in autopsy results. If 6+ months pass with no cause of death determination, suggests medical examiner can't figure it out, may result in undetermined ruling. Sign 2, no charges filed after autopsy complete. If autopsy determines cause but no charge filed, suggests insufficient evidence to identify perpetrator. Case may be waiting for additional evidence that may never come. Sign 3, public statement changes. If police stop saying active investigation, if they start soliciting tips from public, will kind of suggest no suspects, and if the updates become infrequent or stop entirely. Sign 4, media attention fades, as they always do. Next top story, oh, we care, and then next top story comes, and that's all they care about. If cases drop out of news cycle, if social media moves onto other topics, makes it harder to generate new leads. Sign 5, investigative resources relocated or reallocated. Detectives assigned to other cases, if case is no longer a priority, natural result of time passing without breaks in cases. Sometimes the detectives, when they get reassigned, they wind up doing this on their own time because it's still connected to them. They get connected to it. Current assessments, so again, we're 6 weeks in as of October 18th. Case is not yet cold, still in active investigation phase, toxicology pending, critical evidence, digital forensics ongoing, multiple agencies working it, media attention still high, likely trajectory. Scenario A, most likely if homicide, charges filed within 3 to 6 months of discovery. Autopsy determines cause of death. Digital evidence provides timeline and motive. Sufficient probable cause to arrest. Case proceeds to trial. Scenario B, case stalls but remains active, about maybe say 6 to 18 months. Autopsy inconclusive or delayed. Evidence insufficient for charges yet. Investigation continues but slows. Periodic updates but no breakthrough. Scenario C, case declared inactive, 18+ months. All leads exhausted. Insufficient evidence to charge anyone. Case moved to cold case unit. May be solved eventually with new technology or tips. Prediction for this specific case. Given the high-profile nature, resources dedicated, and relatively recent occurrence, this case is unlikely to go completely cold. Most likely outcome is either charges filed once autopsy is complete, if cause of death supports criminal charges, or a case closed if death determined to be accidental and DA declines to prosecute concealment. The wild card, the public pressure, high-profile cases face intense pressure to solve, may lead to premature charges with weak evidence, is why I did this video, or may ensure a case never truly goes cold because media keeps attention on it. So the last part is my conclusion. These are the areas requiring further investigation, and I'm asking you guys, please just be patient. I think there is stuff in the mix here. This expanded wait time, I could close it. I don't know, is because there's still work to be done. I think I tried my best to explain as clearly as I could why there's a delay. So we may not want to keep asking because that pressure, it just causes more people to surface and just say bullshit because they know there's attention on it. And it becomes more of an obstacle to work around because you don't know what is true or what is not. And I think this case, out of respect, we're still in that initial time frame. So let's see what happens. Have trust in the people that are doing it because they know best. And for the people that are coming out just because they want to say something little to keep you fed, try not to get caught up in that either, because sometimes I get caught up in that. Because in the end, we wind up making assumptions that really are based on other false assumptions. And then, Celeste Rivas Hernandez, right? She went from a victim to someone who chose her path by running away or or whatnot, and now it's on her. I mean, look how quick those narratives change. You know, we just got to watch what we're taking in. I hope you guys enjoyed the content. It was a lot here. Well, please tell me what you think. And as always, guys, stay safe.